transfer. The family matter is that the learned trial, the judge is going to retire in this month, but he has taken some biased stand against the petitioner that he will deliver the judgment during his tenure. And he has fixed the case for judgment also without even argument. So, my lord, very serious matter. Let me be taken tomorrow, my lord.
The statements you have made on oath,
My lord.
the statements which you are making now, have you stated it on affidavit?
Yes, yes, I have started in the affidavit.
Okay, let us have it tomorrow.
May I speak? Lordship, item number 6 of today's list, my lord. I am for the petitioner, my lord. And now he is for the caveator, my lord. He has filed the affidavit yesterday afternoon, my lord. Just now I've got the affidavit and it is not in the record. And moreover, my lord, I have been informed by the section, the scan copy of record has already been received by the section, my lord. So can it be taken some other day, my lord? On Monday, lord, 24th, some emergency is there, my lord. In the case.
Okay, item number 6.
Item number 6, my lord.
It is submitted that the respondent, both the respondents,
Yes, sir.
that the respondents have entered appearance through learned counsel, who has also filed an affidavit of opposition, which, however, is not with the record. Full stop, para. In the interest of justice, list list this case on Monday, 24th, 24.
25 for disposal, lord.
Let us see 24/7
For disposal.
along with the affidavit in opposition file. Full stop, para. The names of the learned counsel for the respondents be reflected in the cause list.
And the scan copy of the scan copy of record may be called. It is available.
The learned counsel has also informed this court that scan copies of the LCR has been received by the section. Full stop. The said copies may also be tagged with the records of this case.
These RSA may be listed for orders on Friday, my lord.
Matter of what matter?
My lord, matter relates to a selection and appointment of 2013, my lord. Because of concurrent finding is in favor of me, my lord. Because of this case, my lord, I am not getting appointment. My lord, already out of 5 posts, 3 have been filled up, my lord. If further delay, my lord, I will not.
What is the stage of the case?
My lord.
What is the stage of the case?
My lord, I was selected.
No, what is the stage?
Stage is, my lord. There was a substitution, my lord. Because of substitution, already the person who has been substituted, he has appeared, my lord. So it can order after other, it can be listed for hearing, my lord. That's why I'm paying for the orders, my lord. Oblige.
May I please, your lordship? Lordship, I beg to mention item number 16, lordship.
Yes.
Kindly matter be adjourned for 1 week, lordship. With the I have taken consent, lordship.
On a prayer made on behalf of the petitioner, matters adjourned to be listed after a week. 16.
Oblige.
May I please, your lordship, beg to mention to interim application in MSC appeal for listing of on Friday
Interim applications for
withdrawal of money insurance.
May please the lordship. Can you list the matter, lordship? It is MSCD matter. It come in admission orders columns, lordship.
what is the stage?
It come in orders, lordship.
No, why? What is
In last, lordship, I am respondent in respondent number 2 in claimant. Lordship, I have notice was issued on 17/8/2022, lordship. So, lordship, till date is not.
21.
Lordship, next week anything. And lordship, another matter is lordship, and CRP is there, lordship. It's CRP, lordship, civil revisions. It's relating to MSCD case, lordship. My case has been dismissed as because, lordship, the insurance companies belong to foreign country, that is Bhutan's, lordship. And incident took place at Guwahati in the year 2012. But till date, lordship, that insurance company not appeared. That's why my case has been dismissed, lordship. So that's why, lordship, I have filed an CRP. Lordship, that's matter may be.
What is the stage?
That lordship in order columns, lordship.
Okay.
Lordship, highly obliged.
May I please, lordship? Therefore, listing, lordship, I for release of 50%, lordship. Next page, lordship.
May I be the lordship? Lordship, I beg to mention for listing on RSA, lordship. It was last listed on 4th April, lordship.
What is the stage of the case?
Lordship, it's, case was in the year of 2010, lordship. Now order.
Yeah,
We have filed
The
IF for substitution of
appeal is
legal.
of the year 2010.
Yes, Lordship.
When do you want?
Lordship.
When do you
Within
want?
this week, any day, Lordship.
Okay, Friday.
Of last Lordship.
Lordship, I beg to mention the CRP IO for listing Lordship in stage of motion, your Lordship.
IFR,
CRP IO,
PRP IO. You want a more, it will come up for motion.
motion, your Lordship.
It has not come up
It has
earlier.
come on last 28, but at the time we had to take time. CM
Friday.
oblige, your Lordship.
Very clear, Your Lordship. I beg to mention item 12 of the daily list.
Yes.
I've taken the consent of the other side. Also.
Hmm. Important matter.
Yes, Your Lordship, but the senior counsel HK Deka is out of station, Lord. For that reason, Your Lordship may fix a date on 1st of August. I've informed the other side. Also.
Important matter, we can accommodate you, but you cannot adjourn like this. 1, 2 to 3 days, maximum a week.
Okay, then, Lordship, in this week only, Your Lordship may fix it.
We are not taking up today. We are directing listing of this matter on Monday next.
No, Lordship, till 25th, he'll be not there. Very sorry, Your Lordship. 27th, Your Lordship.
We'll fix it on 27th, okay? A prayer for adjournment has been made on behalf of the respondents on the ground that the senior counsel is out of station for Sapera. However, considering that the RSA is of the year 2014, while 14 comma, the matter is directed to be listed for hearing on 27th.
Maybe, Lordship, part 2 hearing is item number 9. That may not be taken up today. We have somehow misplaced the file, taken the help of the appellant to reconstruct it. Item number 9,
9 of which year?
2009. ma'am.
Today we will not take up, but we'll
Next week, well, Tuesday.
part 2, there are matters of 2, 8, 6. We'll take up part 2 matters today.
Yes, well, next week, well,
9 will not take up today.
much of like.
May please use your lordship.
Yes.
Actually, by last order, the honorable court had directed that the LCR be called for. Already the photocopy of LCR was there because the hearing took place, and then the court felt that the original LCR will be required.
Is it
But
not?
the registry has given a note that Lordship Vittaru's office note dated 7/23
Right.
that already the photocopy of LCR is there, but that was there. We needed the original copy. Lordship. So
Is there any order to call for the original? LCR?
yes, Lordship. The Lordship Vittaru's order dated 6/6/23. Court
6,
order 6/6/23.
last order.
Last order.
Yes, Mr. Jain, what is?
Lordship, because the matter was last date, it was for hearing, Your Lordship. Lordship may fix a date, Your Lordship.
The moment the LCRs are there, we can go. Why is the requirement for LCR in original?
Because Lordship, the policy that the claimant herself, not the owner, she exhibited the policy. So in the photocopy, we cannot ascertain whether it is
Okay,
because we
it
are
was-
denying the policy.
Okay. The photocopy was not distinct. So you
Not,
did
not
No, no,
exactly, not a
Lordship,
question
that
of distinct Lordship.
Lordship,
Question-
that it is wrong submission, Your Lordship.
No.
They have already filed a policy with their affidavit. They have already filed. Now they say it is not, it is their policy. They say
No,
the policy
Lordship,
is
the policy.
just I am submitting. The
No,
policy.
since you're saying I'm
the-
making
the-
wrong submission, I got
the
to
policy-
object it.
Lordship, my landed-
we'll come to you.
Lordship, my landed friend, they have already filed affidavit. They have, in which cross objection, they have annexed the copy.
Of the
So,
policy.
Yes, copy they have annexed. They say the copy, the chassis number and this engine number, they differ from the policy filed by the owner. Now, some different submissions is making
No.
that what for original is called for. Original, that they filed the policy. I have exhibited.
Are you depending on the policy filed by them?
Because their policy,
No, Mr. Jain.
my policy,
No, Mr. Jain.
I am claimant, Your Lordship. Owner has filed a policy.
Understood. You say that in their cross examination. objection, they have also annexed copy of the policy.
Yes.
Are you disputing this policy?
Yes, I'm disputing, they have not filed any policy in the trial court. They have not filed. They filed only in the appeal.
Okay, let the originals come. I think.
Then I'm not disputing, but why it is
Understood.
required, I am disputing
Yes,
that.
sir. Do photocopy of the LCR of MSC case number 489, 2013 was already requisitioned from the MACT Borpeta, comma. This court, by order dated 6/6/2023, had directed calling for the LCR. Full stop. The learned counsel for the parties have appraised this court that there was some dispute with regard to the contents of the policy for which such order was passed. Full stop. Para. Office note dated 10/7/2023, however, reflects that LCR within bracket photocopy was already received from the MACT Borpeta in the year 2018. Full stop. Para. The direction was to call for the LCR by order dated 6/6/2023 and not the photocopy of the LCR. And therefore, the same direction is required to be complied with immediately. Full stop. The registry is accordingly directed to take immediate steps for requisitioning the aforesaid LCR in original from the MACT Borpeta as the claim is of the year 2013. And on receipt of such LCR in original, comma, the matter will be listed for hearing.
Lordship, the order was to send a special messenger.
No, we'll have it, don't worry.
And Lordship, the date may be fixed, Lordship, because
We cannot fix a date for LCR unless it comes. What is the,
because my application next, my application for interim relief was there because the accident took place on 13.
Mr. Jain, have you listened to what we have passed? We have said list immediately on receipt of the LCR. What else do you need?
I have a small prayer, Lordship.
In this case,
Yes, Lordship. Only one in I, Lordship, earlier I filed on a Lordship, in I number, Lordship, 4378, Lordship, I don't know 2, Lordship, in I, Lordship. But actually, here, Lordship, the party already engaged, in the main case, Lordship, they have engaged another advocate, Lordship. But they all them maybe detailed, Lordship, the 2 advocates, Lordship. The name,
IA number?
4378, in item number 2.
That is already disposed, Lordship,
That was
because the
under-
item number 2 is in fact, we have withdrawn, we filed the appeal, we have withdrawn because we filed. the-
Maybe deleted, Lordship, Islam is coming, Lordship, now.
Who has been disposed? There is no question of deleting.
Yes.
Appeal has been disposed of what?
I do not know, Lordship.
Why is it then connected? Same accident.
Same accident, one by, so it may be there, so it will be required.
Your presence will not be required. It is only the records.
Already owner is appearing.
We have said that it will be listed immediately on receipt of the LCR. Don't worry.
Highly obliged.
Yes, next. Yes. Review.
Yes, my lord. Only this point is, my lord, this, this honorable court, my lord, the Rodas class, my lord, the, it was, we have not challenged his OBC certificate, my lord. But our case was, my lord, when he applied, my lord, for a post of lecturer, my lord, he produced certificate, OBC
Mr.
certificate.
Mehdi, you have to narrate the facts. We have forgotten. We don't remember the old case. What was the matter petition about? You are the petitioner.
My lord, here, my lord, the respondent, private respondent, my lord, he applied for the same post, my lord.
Applicant is the petitioner, petitioner.
Applicant read petition.
Yes, what happened?
My lord, in a post of, my lord, the so and so government college, my lord, the education department, my lord, it was reserved for OBC, my lord.
There was a post vacant.
post.
There was a recruitment process
Yes, my lord.
by the advertisement.
Yes, my lord.
What is the date of the advertisement?
Advertisement date,
What
my
is the
lord.
name of the college?
Advertisement date is 13/8/2020, my lord. Page 3738, my lord. 13 August 2020.
2020 advertisement.
Yes, my lord. PS, my lord, 37 and 38 of my review application, my lord.
Mr. Mamata, have you seen? We'll come back. Page,
PS,
Repeat.
starts, my lord.
where is the advertisement date?
Date, it is.
No, I mean page
Page is 36, my lord. 36, 37, my lord. And
30,
and
36.
this type copy, my lord. And 38, my lord, it is.
Okay, doesn't matter. This
Yes.
is the advertisement.
Yes, my lord.
What is the college?
It is government, Pandit Dindal Upadhyay Government College, my lord. Government model. College.
Advertisement for?
For the post of, my lord, for the post of lecturer, assistant professor, my lord, education, my lord.
Assistant Professor Educate.
Education, is page 37, my lord.
Okay, Professor, no, Pandit Deen Dayal Upadhyay Government Model
Model.
College.
Yes.
This is in Hailakandi.
Yes, my lord.
Then what happened? You put,
My lord, there is 3 posts, my lord. 1 post reserved for OBC and MOBC, my lord.
there are 3 posts in the for the state.
Yes, my lord.
3 vacancies.
Yeah, for Department of Education, my lord, 3 posts, 1 reserved, unreserved, 1 for OBC, MOBC, 1 for SC, my lord.
1 reserved, 1 for OBC.
1 for general, my lord, unreserved, my lord.
Oh,
and
one OBC.
One the 1 for OBC, another for my third one for SC, my lord.
Yes, okay.
Yeah, I am on my post of OBC, my lord, OBC, my lord. Here, what happened, my lord? The respondent, as well as the requisition that they applied for the said post, my lord. My lord, the
Mr. You are for response number
private respondent, my lord.
Respondent number 6 of the review petition.
R6. Okay. You both applied.
Yes, my lord.
Thereafter,
Well, the requisition came to know, my lord, that he is from he is OBC from West Bengal, my lord.
the respondent.
Yes, my lord.
Okay.
And accordingly, he, my lord, they made a complaint also before the director, my lord. And my lord, what happened, my lord, in other college, my lord, other same government college, my lord, in Borkola, my lord, in Kasar district. My lord. The respondent, my lord, applied for the state college also, my lord. My lord, in that part, this college, my lord, Hailakandi college, my lord, Pandit, my lord, Pandit Dindal Upadhyay college, my lord, I applied for all documents before the principal, my lord, put through RTI, my lord. But it was not supplied, my lord. My lord, ultimately, my lord, the annexer N, my lord. Annexer N, my lord, this, there is a,
Page.
annexer N to the rate petition.
Page.
Yes, my lord. Annexer N, my lord, the page 64, my lord.
Yes.
My lord, this is from the office under signature of Director of Higher Education, my lord, to the principal, my lord. It is my the date, my lord, 18 August 2021, my lord. My lord, here, my lord, there's the invitation for ceremonial distribution of appointment letter. In my lord, it was my lord, in my lord, Kalakshetra, my lord. And annexer A, my lord. Annexer A page, page, my lord, next page, my lord. Page 65, my lord. Serial number 11.
Yes. This is your college.
Yes, my lord. This college, my lord. Where my lord respondent is working, my lord.
Yes. Yes.
My lord, the respondent was appointed, my lord. As per this letter is that, my lord, 18 August 2021, my lord.
Her name is Mohammed.
His
His
name,
name is Sarwar Jahan.
Yes, my lord, his name, my lord.
That's one was 6.
Yes, my lord. Somehow we collect this letter, my lord. We approach this honorable court, my lord. The honorable court, initially, my lord, after hearing, my lord, in the first stay order, my lord, against his appointment. My lord. At that time, we could not, my lord, produce the appointment letter of the writ petition, the original appointment letter.
Understood.
But thereafter, they filed a petition for vacating stay, my lord.
Hmm.
We file objection, my lord.
Okay.
In that objection, my lord, we will also annex some documents, my lord, in other government college, my lord, where he's produced, he annexed the certificate of the West Bengal, my lord. But here, my lord, we could not obtain his documents, my lord, because principal, my lord, is not in, he's in his favor, my lord. So, my lord, even we approached director also, we could not, my lord. So in the objection, we filed that he in another government college, he filed in two application form, my lord. In one, my lord, he himself declared it as general, my lord. In other, my lord, he is OBC from West Bengal. My lord. Well, here, my lord, the government has not filed an affidavit in writ petition, my lord. After hearing this honorable court, my lord, page 73, my lord.
Yes.
Page 73 by your lordship, my lord.
Yes.
I'm reading, my lord.
Hmm.
The connected interlocutory application has been filed by respondent number 7 for modification of ex parte interim order dated 22/9/2021 passed by this court in connected with writ petition. Writ petition has put challenge the appointment of the respondent number 7 as assistant professor in the Department of Education in Pandit Dindal Government Model School, Katlisara, in the district of Hailakandi. The genus of the challenge pertains to the claim of respondent 7 belonging to the reserved category of OBC. The petitioner has demonstrated that the said respondent number 7 is a permanent resident of the state of West Bengal, and he has been stated to be belonging to the another caste of appropriate authority by the state of West Bengal, which is different from the caste declared by the state authority of Assam. Since there is an anomaly in the caste of respondent, the writ petitioner has raised serious issue regarding the appointment offered to his pursuant to the recruitment process initiated by the advertisement dated 13/8/2020. This court, by order dated 22/9/2001, while issuing the notice, had directed that any appointment given to the respondent number 7 pursuant to the advertisement dated 13/8/2020 shall not be given effect until the further order. It is the interim order which has been sought to be modified in this connected IA. Ms. R. Devi, Learned Counsel for the respondent number 7 applicant, has submitted that even before the interim order passed, respondent 7 was already given appointment by order dated 29/2021 and joined in the said post. Therefore, in the interim order is actually infructuous. On merit, the Learned Counsel for respondent 7 contended that the proposition advance on the behalf of the petitioner that belonging to an OBC category in particular state may not be automatically conferred the same status. The another state may be a correct person. The facts are totally different in the present case, as the competent authority of Assam has already declared respondent 7 to be belonging to the OBC, and the certificate is not the subject matter of the challenge. This was my lord, their submission. K. Gogoi, Learned Counsel for the Higher Education Department, submitted a certificate by respondent 7 has not been has been declared to be belonging to OBC category, not being subject matter of the challenge. The appointment offered to say respondent 7 perhaps not been cannot be challenged in the writ proceeding. Further contended the issue well involved the factual metrics which may not be able to be executed by this court in exercise of this writ jurisdiction against the IA. The writ has also filed objection. This court has put it in consideration and to rival submission and advance on behalf of the parties, and also produce the material on record. From the pleadings and prayer, though it appears that the action of making appointment has been put to challenge, the appointment order has not been mentioned. Though this said action has not is not found by this court, as the appointment itself is a subject matter of challenge. This entries of this code is that the basis of appointment, namely the category of the appointment of category of, in which the appointment of the respondent 7 has been made, namely OBC, has done its challenge by writ petition in any specific manner. Unless the claim of the respondent number 7 is successfully challenged, the challenge to the appointment only on the ground of caste will not be sustainable. Further, court has noticed that the claim of the respondent is forfeited by the certificate issued by the competent authority of state of Assam, which has been declared respondent 7 to be belonging to Jolha caste, which admittedly OBC in MOBC category. Though it appeared that there is some anomaly in the caste mentioned in the appropriate authority in the state of West Bengal by the caste mentioned in the certificate issued by Assam, it will not be the cleansing ground warranted in the present challenge. In view of the above court, this court viewed the present challenge is devoid of merit and accordingly writ is dismissed. However, it is made clear dismissal of the written shall not stand on the way the petitioner make appropriate challenge to the claim of the respondent number 7 belonging to the category of OBC MSC. It needless to state that in such challenge guidelines laid down by the Supreme Court in case of Kumari Madhuri Patil so and so shall be adhered to. Accordingly, writ petitioners stand disposal. This order was passed by the Honorable Court, my lord. At that time, my lord, the state respondent has not filed an affidavit, my lord. Against this order, my lord, the writ petitioner preferred appeal before the division bench, my lord. My division bench, my lord, in division bench, my lord, the state respondent filed affidavit, my lord.
Affidavit 110.
Yes, my lord. It is from my lord, page 77, my lord.
Yes, yes.
So for my lord, is from page 78, my lord, paragraph 4. Dependent Vex said the principal Pandit Dhyandal So-and-so College has published advertisement on 13/8/2020 inviting the application for the state post so-and-so in the department reserved OBC and OBC college. In interview was held on 9/11/2020. From the 5, it is important. Madam. The deponent Vex said the principal Pandit Dhyandal Model College submitted a proposal by letter number so-and-so dated on 4/12/2022 for appointment of assistant professor in the Department of Education reserved for so-and-so. In respect of selected candidate Mohammad Sawar Johan, OBC, NET PhD. After observation on the proposal it is seen that the OBC category of caste certificate Dr. Mohammed is from West Bengal outside the state. This was my lord. It is further state that the application for the post of assistant professor petitioner fill up in present so-and-so Assam. The deponent said the principal of the college informed. Principal of the college has informed by office letter number 22/2/2021. Dear time he informed my lord that the post of reserve OBC MOBC category and selected candidate Mohammad Sawar Johan is having OBC certificate from West Bengal, which is treated general category in the state of Assam, and also informed that the proposal submitted by so-and-so on 4/12/2022 is regretted for appointment as the assistant professor in the Department of Reserve for OBC and OBC category of the college and request him to re-advertise the post immediately after as per latest government memorandum. This was my lord, the affidavit file. This was the crux of the matter, my lord. The deponent further stated that in response to the letter 22/2/2021, the principal Pandit Dhyandal College, Upadhyay Government so-and-so, has addressed a letter dated 22/3/2021. It is March, my lord, to the director enclosing OBC caste certificate from caste certificate of Dr. Mohammad Sawar Johan from state of Assam, issued by the so-and-so on 15/7/2005, which was countersigned on Deputy Commissioner so-and-so, and applying for the has submitted a permanent residence certificate. This was the case, my lord. When he was the man, my lord, the other documents or the other his caste certificate submitted from the West Bengal, my lord. And subsequently, when it was rejected by the director of Hadikon, that principal, there's no who submitted. Principal himself submitted the certificate from OBC from state of Assam, whether he's the respondent six submitted or there is no history also, he
No,
himself.
Paragraph 7, we have not understood what is it.
In response to the letter of the
No, no.
director, my lord.
In, please read paragraph 7 again.
Yes, my lord. In response to letter dated 22 to 2021, this letter from DHC, my lord. The principal of Pandit Dindal Upadhyay Government Model College, Kathaleswar, has addressed a letter dated 22/3/2021 to the director enclosing OBC certificate. He enclosed OBC certificate of Mohammed Dr. Saraj Jahan from state of Assam, issued by the chairman of subdivision OBC Development Board, Karimganj, so dated 15/7/2000, which was countersigned by Deputy Commissioner, and also stated that at the same time, at the time of applying for a post, Saraj Jahan submitted permanent residence certificate Assam. The principal stated, my lord, he is from state of Assam, OBC, my lord.
No, principal has enclosed
Yes, ma'am.
a certificate by the OBC Development Board, which was countersigned by the Deputy Commissioner.
Yes, ma'am.
Is the authenticity of this certificate questioned by you?
No, my question, when he produced, when applying, he's a candidate from the West Bengal, West Bengal OBC. So my question, with that question, I've never raised, and so far, his West Bengal certificate, that certificate is Kotha community, and here this which certificate, I'm just for understanding, the Jolha is tea garden, tea garden.
No, we are not,
yes,
we are not on that.
yes.
We have understood your main point, that the government itself has stated, the affidavit has stated in paragraph 6, that the certificate which he was relying upon pertains to a community in West Bengal which is regarded as OBC, and that community is not OBC in the state of Assam.
Yes, ma'am.
That is the point you are
Yes,
trying to. But in paragraph 7, there is a reference to a certificate of 2005
Yes, ma'am.
by the state of Assam,
Yes, ma'am.
by a competent board of the state of Assam, which is also countersigned by the Deputy Commissioner Karimganj.
Yes, ma'am.
Are you disputing this certificate?
My only point is, when applying a man, in a particular certificate from particular state, he cannot, subsequently producing another certificate.
You want to contend that this certificate of 2005 was not in the picture at all.
Yes, ma'am. Now
He
subsequently.
had applied with a certificate from the state of West Bengal,
Yes, ma'am.
which ultimately cannot give him any benefit because that particular community caste is treated as general
Yes,
in the
ma'am.
state of Assam.
Yes, ma'am.
And this development by the principal in his response will not give him any benefit.
Yes, ma'am.
That is your
Yes, my lord, because it is in paragraph 6, my lord, and the director himself submitted the affidavit, my lord. I'm reading, my lord. Principal of collection informed.
Is the principal has he appeared?
No, my lord. No, my lord. And my lord, as stated as general category, he himself, my lord, it was, my lord, having from West Bengal, my lord. This, my lord, when a man, my lord, applying from certificate from another state, my lord, subsequently they produce the another certificate, my lord. So without this, it is permissible or not, my lord. And your lordship is aware of there is a judgment of the apex court also from Guwahati High Court, my lord.
Now, what was the direction of the direction in the appeal?
Appeal, my lord, is only, my lord, the appeal, my lord, says, my lord, the last page, my lord.
Page?
Unless 105, my lord. During the course of hearing, it was pointed out the last date of considering application of
Just a minute. Order dated.
my lord.
What's the date of the order?
Order is 22/11/2022. Last page, my lord.
Then writ appeal
Writ appeal, my lord.
110.
Yes. 110, my lord, 2020.
Yes.
During the course of hearing, it was pointed out the last date of consideration of application of 26/8/2020. This should be 2020, my lord. Whereas the certificate issued by the authority was placed into service was much later to the to said due date. So
Much after.
yeah, yes, much after. Learning Council for the applicant contained that the said point was raised, however, the same was not considered in line of single judge. In such scenario, the applicant for the appellant to file appropriate application for the declaration of the same. The appeal is adjourned, so and so. The appeal is pending, madam. This is clear.
What is the meaning of during the course of hearing, it was pointed out that last date of consideration of the application was 26/8/2020,
Yes, madam.
whereas the certificate issued by the authorities was pressed into service.
Much later, much second, certificate from second Assam, madam.
When was that certificate given?
Which one, madam?
The second certificate?
Second certificate, my lord, is subsequently in paragraph, my lord, 7, my lord, the affidavit it is stated, my lord.
Okay, okay. The principal's response
Principal response.
to the
Principal-
directorate.
Yes, ma'am. Principal, my lord, it is annexed, they also annex the certificate also, ma'am.
Where is it?
This is my page 87, page 87, ma'am, 85, ma'am. Page 84 and 85. Eighty-four letter from the principal, my lord, page 84, my lord, in review petition.
What is the contents here?
Which-
Page 84.
84 is a letter from
No,
the
no,
principal.
please read this.
Reference to DHC letters dated 22 2 2021. Madam, with reference to the letter under reference on the subject cited, I have the honor to inform you that the selected candidate so and so submitted his OBC certificate from the state of West Bengal. Submitted West Bengal certificate and PRC from Assam. Earlier at the time of applying for the post. Now he has submitted his OBC certificate from state of Assam. Therefore, he may be treated OBC candidate from Assam and copy of enclosed here.
Oh.
Melody, they also admitted that there's been at the time of Melody certificate was submitted. Melody.
During the application, he submitted
Yes.
OBC from West Bengal.
Yes, ma'am. Subsequently, it was submitted.
And it is the stand of the government that that
Melody,
certificate which categorizes him to be OBC in West Bengal is a general candidate in Assam.
It was Melody. In this, if they file affidavit, Melody, and this at the time also it is. But not filed.
Okay. Yes.
And another thing, Melody, only for Lordship, Melody, this the in my lord, the additional affidavit I filed this, my lord, because of this review petition. In review petition, I have not annexed, my lord, the intellectual application and objection, my lord. So, my lord, I filed an additional affidavit, my lord, to bring the record, my lord.
Yes.
My lord, if lordship turn, my lord, pays, my lord, this 143. Running pays, my lord. In different government college, my lord. In state of Assam, my lord, he applied, my lord.
143 is a part of what?
My lord, part of my additional affidavit, my lord.
Okay. Page
143.
Yes.
In pursuance to the advertisement that my lord, advertisement of 2020, my lord. This my application file in another defined college or government, my lord, same capacity college, my lord. In CL7, my lord. CL number 7, number 7.
Yes.
CL7,
Yes.
permanent resident, president, if permanent resident address. So and so Malda, my lord, village, so and so, post office, so and so, district Malda. He himself, his handwriting, my lord. And my lord, here, my lord, himself declared OBC, my lord. But in the state course, he did not attend before interview. And my lord, the second one, my lord, page 145,
OBC, sir.
my lord.
Here also he was OBC, sir.
Yes, my lord, OBC West Bengal, my lord. I'm giving, my lord. And my lord, this, my lord, and my lord, this page 145. In same government college, my lord, Assam, my lord, he at category 5, he himself is general category. And my lord, page 149.
1 second. Okay.
And 149 and 150, my lord. This certificate from the OBC from West Bengal, my lord. Type copy is for 139, my lord. This is page 158, my lord. This photocopy, my lord. This was issued, my lord, in 2012, my lord. Kotha Muslim, my lord. My lord,
149.
Kotha Muslim, my lord, they are Uyghur, my lord. Uyghur in West Bengal, my lord. And my lord, I'm not challenging them here, my lord. This OBC, but Dulha Muslim, my lord, Dulha, there is no Muslim community, Dulha, my lord, OBC, my lord. And Dulha is, my lord, the only tea garden community, Muslim, tea garden community, they are Dulha, my lord. So there is no Muslim community Dulha. This one also the practical fact, my lord. So this certificate, my lord, 150, it was produced, my lord, the another college, my lord, when he applying, and in this certificate also produced when applying for this the present post, my lord. It is probably in the record, my lord, in a record of the state of Assam department, my lord. This when initially, my lord. So my simple case, my lord, this is when the man applying the certificate OBC from different state, my lord, which is not the same status in the state of Assam. He is not eligible for the state post. He should be treated as general. He cannot apply for the post of reserved category. And well, here your lordship, ever, my lord, this judgment from the Guwahati High Court, my lord, itself, my lord, this one Bedanga Talukdar, he the APSC matter, my lord, he locomotory, my lord, handicap. My lord, initially when advertisement was, my lord, issued, my lord, it was not. Subsequently there is given chance to in present certificate, which are at that time also he is not produced, my lord. Subsequently he after much later, my lord, he submitted. But this honorable court is allowed, my lord, his certificate. This on the Guwahati High Court, my lord. They apex court, they challenge the apex court. Apex court says no. When if there is no relaxation and nothing is there, they can this documents cannot be accepted. I'm supplying this. He's my locomotor handicap, my lord. But he's but he's at the time of my applying, my lord, he's not produced certificate. But he was not considered by the apex court, my lord. APSC.
Which paragraph?
My lord, the disposal for my lord, this paragraph, page 11, my lord. I'm just reading, my lord. 11 last, but last, not before that. Lordship is getting. Though Sheikh Khan has mentioned in his letter dated so and so, 10/12/2019, he was resubmitted the identity card with regards to document disability. In fact, he submitted documents of proof to document disability for the first time to APSC office through his above letter dated 10/12/2019. However, after receiving the identity card, the matter was placed before the full commission to decide whether the commission can be act on the essential documents not submitted earlier as per the advertisement, but submitted after completion of the entire process of selection. Commission, while examining the matter in details, observed that
Okay, we have read.
my lord,
We have read.
and last my lord, last 31 my lord, it is there, my lord. He was treated general candidate, my lord, and accordingly, my lord, the appearance, my lord, whom he was allowed, my lord. This is my case, my lord, before this one was concerned. And my lord, only thing, another thing is he's my lord, whatever my lord he submitted, my lord, this PRC is from Hailakandi, and my lord, OBC certificate from Korimganj, my lord. There also some, my lord, there is no doubt, my lord. And when division mentioned, when directed to file affidavit, my lord, it was my lord, the expression of court, my lord, how the man can obtain two certificates from the different state. So my lord, directed to file affidavit, accordingly they file affidavit, my lord. This was the.
Lordship, may I submit now?
Anything else? Any more sufficient?
My lord, and my lord, so far, my lord, your lordship is ever, my lord, this, so far, my lord, this, decision of bleaching, my lord, bleaching of Delhi Jal Board, my lord, regarding my lord, this purpose from other state, my lord, he cannot be my lord, treated as a same status, my lord. This submission, my lord, this case is 2018 10 SCC page 312, my lord.
2018.
2018 10 SCC 312, my lord.
Which para?
Well, I'll indicate, my lord, but some photocopy, my lord, I'll indicate.
Not name of the case.
Name, my lord, Bir Singh versus Delhi Jal Board, my lord.
BIR.
BIR, BIR. Person belonging to ST/SC in one state cannot be deemed to be ST/SC in other state, my lord. This was the case, my lord. So, my lord, so far reservation is concerned, my lord.
Yes.
I'll reply, my lord.
Yes. Mr. Kamildar, you would like to say something? Then we'll hear you after him or what? Since he's the contesting respondent. You are for R6.
R6.
Yes.
Lordship, the issue is that we are not in the writ petition. It is a review petition. And the review petition can be filed to evaluate the decision-making process, not the evaluate of the merit itself. The purpose of the review petition is to ensure the fairness in treatment, not the fairness in conclusion. So and it is the, as the settled law, so the review petitioner has to establish that there is some infirmity, irregularities while making the decision which violates the principle of natural justice. This is the ambit and scope of the review petition. The review petition cannot be argued in the merit unless there is some irregularities, infirmities which violates the principle of natural justice of the review petition. And my learned friend, whatever he has submitted, this is stated in the writ petition, that I am from the state of West Bengal, that I have submitted certificate initially from the West Bengal, and later on I have obtained certificate from the state of Assam. These are the decided facts, and the admitted position is that there is no infirmity as from his submission as well as from his petition. So Lordship, the genesis of the review petition is on the page number 105. Thus, my friend is read out the portion. During the course of hearing, it was pointed out that the last date of consideration of the application was 26/8/2022, whereas the certificate issued by the authorities was pressed into service much after the said due date. This part is important. Mr. So-and-so, learned counsel for the appellant, contended that said point were raised, however, the same was not considered by the learned single judge. This is most important, Lordship. So genesis of the review petition is that my review petitioner has submitted, yes, I have raised the point that late submission while filing the writ petition and while making decision of on the writ petition. But the learned single judge did not consider my point. And on that ground, he has obtained the liberty to file this writ petition. Now, Lordship, I may come out the ground that he has stated on the writ petition, which is on the para number 18, page 10 of the review petition.
Page 10.
Page 10, paragraph number 18. May I have your permission to read?
Paragraph 10.
Paragraph, sorry, Lordship, page 10, paragraph 18.
Yes.
That the paragraph 18, Lordship, that the facts and circumstances stated above, the petitioner begs to file this review petition on the following grounds, among others, for that the petitioner came to know after filing the writ appeal number so and so, wherein the respondent number 3 filed an affidavit in opposition that the respondent number 6 submitted the OBC caste certificate from the state of West Bengal at the time of submission of the application, from which was subsequently signed by the college authority for appointment of the respondent number 6 with the proposal of appointment, but thereafter on 22/3/2021, the principal of the said college, that is the respondent number 5, submitted another caste certificate of the respondent number 6 from the state of Assam. The respondent authority cannot accept any document or certificate after the last date of submission of application form. In the advertisement relating to the present post in question, it is mentioned that the application with the relevant document must be reached before the principal on or before 4 p.m. 26/8/2020. That for that, the petitioner was not aware of that there is a direction of the Apex Code dated 28/9/2011, passed in civil appeal number so and so, whereby the Honorable Apex Court observed that it is settled law that there can be no relaxation in terms and conditions contained in the advertisement unless the power of relaxation is duly reserved in the relevant rules and or in the advertisement. It is settled principle of law that authority cannot accept any document after last date of submission, therefore the documents which was submitted by the principal relating to OBC category caste certificate of the respondent number 6 was reflected in affidavit in opposition filed by the respondent number 3, DHE, cannot be an acceptable document, and the respondent authority cannot appoint the respondent number 6 on the basis of the said OBC category caste certificate which obtained from the state of Assam. So, Lordship, this is the fact that the submission made in the division bench, on the basis of that submission, liberty was granted to file the review. And here, the ground is totally different. In the division bench, it is submitted, yes, I have raised the point, late submission. But here it is admitted fact is that, no, I did not raise. I came to know after filing the affidavit of the state respondent. So it is, my submission is that, Lordship, it is a clear incident of the misleading of the court to obtain the liberty to file the review petition. And review petition cannot be filed on the basis of the affidavit which is filed in the appeal, writ appeal. Review petition filed as it is, I will supply the decision of the Honorable Court. It is settled law that it can be filed to evaluate the decision-making process if there is in any violation of the principle of natural justice. But admitted position is that there is no violation. So this petition does not fall within the ambit of the review petition. And the issue which are raised that the two certificate, caste certificate, I am not belong to the OBC category.
Just
Regarding the validity, legal validity and the authenticity of the certificate on the basis of which I have been appointed, it is not put under challenge. Earlier occasion also, this time also, the review petitioner admitted that there is no infirmity, as because it is, when it was submitted, it was verified by the competent authority. The only question.
the Assam certificate has not been put to challenge.
Lordship,
You want to contend that the certificate by the board in Assam
yes,
has not been put to challenge.
yes, it was not put in
Has
challenge.
not been put to challenge,
Yes.
therefore he cannot now say
No,
that.
no, no. I am coming, because he is admitted that his issue is the late submission, because the validity and authenticity of certificate is accepted, because it is verified by the competent authority.
That is the, what your
Yes.
proposition is that the authenticity of the certificate has not been questioned.
Yes,
It is only the late submission.
only the late submission. And Lordship, and the Supreme Court in the Katina decision says that if a person belongs to the OBC or SC category by birth, not by acquisition in any manner, the certificate issued to this effect is only the assertion of the fact. A candidate, appointment of the candidate or benefit of the reservation cannot be denied on the ground of late submission of the caste certificate. While explaining the entire picture of the reservation, the Supreme Court, the principle is laid down in the Tejpal Singh case of Delhi High Court and the Ram Prasad Gijoria case of the Supreme Court and the Indo Sohini case of the Supreme Court. These are the landmark judgment, Lordship. And where it is candidly said, the candidature of a OBC candidate cannot be denied, or he cannot be deprived the benefit of the reservation merely on the ground that late submission of the certificate. Lordship, I'll place the relevant judgment for the kind perusal of the court.
Yes, citation.
Yes. The first case is Lordship Ram Kumar Girodia case reported in 2016 for SSC 754. It's a big judgment, Lordship. And the second page, page number 2.
Paragraph.
I'm reading the paragraph number 3. It is the important question of law to be decided in the appeal is whether candidate who appears in examination under the OBC category and submits the certificate after the
Paragraph 3.
Lordship, paragraph number 3. It is Ram Kumar Gidodia,
Yes,
the
The
appealant.
important question of law.
Yes, the important question of law.
Yes.
To be decided in this appeal is whether the candidate who appears in an examination under the OBC category and submits the certificate after the last date mentioned in the advertisement is eligible for selection to the post under the OBC category or not. This is the legal question decided by the court. Now, Lordship, page number 13, 14, and paragraph number 13, 14, and 21. Lordship, I'm reading out the paragraph number 13. After hearing both the parties at length and perusing the impugned judgment and order passed by the division bench of the High Court, we are of the view that division bench erred in setting aside the judgment and order passed to the learned single judge. We record our reason here and under. The division bench of the High Court erred not in considering the decision rendered in the case of Pushpa within bracket Supra, in case the learned single judge of the High Court had rightly held that the petitioner therein were entitled to submit the OBC certificate before the provisional selection list was published to claim the benefit of the reservation of OBC category. The learned single judge correctly examined the entire situation not in pedantic manner but in the backdrop of the objective reservation made to the reserved category, and keeping in view the laid down by the constitutional bench in this court in the case of Indro Suhini versus the Union of India, reported in 1992, supplementary 3 SSC 217, as well as the Balsamma Paul versus Cochin University and other 1996 3 SSC 545, the learned single judge in case of Pushpa Supra also considered another judgment of Delhi High Court in case of Tejpal Singh Supra, wherein the Delhi High Court had already taken the view that candidature of those candidates who belong to the SC and ST categories could not be rejected simply on ground of the late submission of the caste certificate. Now, Lordship, the remaining portions of the paragraph of the two judgments, I'm skipping this one. I'm coming to the paragraph 21. The Constitution.
Yes.
The Constitution, through its preamble, fundamental rights and directive principles, created a secular state based on the principle of equality and non-discrimination, striking a balance between the rights of the individuals and the duty of the commitment of the state to establish an egalitarian social order. In our considered view, the decision rendered in the case Pushpa Supra is conformity with the position of the law laid down by this court, which had been referred to Supra. The division bench of the High Court erred in reversing the judgment and order passed by the learned single judge without noticing the binding precedent on the question laid down by the constitutional bench of this court in the cases of Indro Suhini versus Balsamma Paul Supra, wherein this court, after interpretation of the Article 14, 15, and 16 and 39A of the directive principle of the state, has held that the object of providing reservation to SC, ST, and educationally and socially background classes of the society is to improve inequality in public employment, as candidates belong to these categories are unable to compete with the candidate belonging to general category as a result of facing centuries of
oppression and deprivation of opportunity, the constitutional concept of reservation envises in the preamble of the Constitution as well as in the Article 14, 15, 16, and 39A of the directive principle of the state policy is to achieve the concept that giving equal opportunity to all sections of the society. The division bench thus erred in reserving and reversing the judgment and order passed by the learned single judge. Hence, the impugned judgment and order passed by the division bench in later patent appeal number so and so is not only erroneous but also suffers from error in law, as it has failed to follow the binding precedent of the judgment of this court in the cases of Indra Suhani and Balsamapal Sutra. Therefore, the impugned judgment and order passed by the division bench of the High Court is liable to be set aside, accordingly set aside. And Lordship, I am relying on another decision. It is a landmark case, Tejpal Singh case, Lordship. Lordship, Tejpal Singh case is the second citation of
Delhi High Court.
Delhi High Court. Lordship, the relevant portion is in paragraph number 7.
Just what is the citation?
The citation is 2002 AD Delhi 428.
No, any other AR or something?
LLR Delhi 298. 2002 SCT 497.
Yes.
Lordship, I am coming to the paragraph number 17. The page number 88. Yes, Lordship, 17.
Matter can be looked.
Yes.
Yes.
The matter can be looked into from another angle also as per the advertisement dated 11 June 1999 issued by the board. Vacancies are reserved for various categories including SC category. Thus, in order to be considered for post reserved for SC category, the requirement is that person should belong to SC category. If a person is SC, he is so by birth and not by acquisition of this category because of any other event happening at a later stage. A certificate issued by competent authority to this effect is only an affirmation of the fact which is already in existence. The purpose of such certificate is to enable the authorities to believe in assertion of the candidate that he belongs to SC category and act therein by giving the benefit to such candidate for his belonging to SC category. That part is most important. Lordship, I am relying on another decision. It is passed by the Honorable Kerala High Court, Division Bench of the Kerala High Court. After Tejpal Singh, it will come.
Abdul Rashid.
Abdul Rashid. Paragraph number 10.
Yes.
The landmark judgment of Apex Court in Indro-Suhini versus Union of India, 1992, 3 SSC.
Paragraph 7 you have read. 7.
Paragraph 10 I am reading.
10.
The landmark judgment of the apex court in Indo-Sohini versus Union of India 1992, 3 SSC supplementary 217 has explained the concept of reservation in its historical background and has laid down the principle for implementation. In Tejpal Singh case, the apex court held that the candidates belonging to the SC and ST categories who submitted the community certificate belatedly were also eligible to be considered for appointment under the reserved category. In Puspa versus Government and City of Delhi and others reported in 2009 to close Delhi, within bracket Delhi 278. With regard to the late submission of the community certificate of an OBC candidate, the apex court held that the person belongs to the OBC category by birth and not by acquisition of this category because of any other event happening at the later stage. The certificate issued by the competent authority to this effect is only an affirmation of the fact which is already in existence. In Ramkumar Gijoria case, that I have referred earlier, the 2 cases, it is also reported, mentioned in the Kerala High Court decision. In Ramkumar Gijoria case, the apex court considered the question of law as to whether a candidate who appears in an examination under the OBC category and submits the certificate after the last date mentioned in the advertisement is eligible for selection to the post under the OBC category or not. Deciding a batch of civil appeals, it was held that the judgment of the division bench, setting aside the judgment order dated so and so, wherein the learned single judge had allowed the petition and directed the respondent to accept the OBC certificate produced belatedly, was erroneous, and the same was set aside. Direction to consider the appellants for selection and reservation category was thus upheld. So, Lordship, this is the settled position of law that a person belong to the reserved category. He may submit the caste certificate after, but he has to make declaration in his application that yes, I am belong to the OBC category. So my case is clearly covered that I have declared that I am OBC category, but the certificate which I have submitted somehow rejected, and the certificate I have submitted later on it was verified and accepted. Now the question will come that why these 2 certificates? This is a vital question that my learned has raised the question, Lordship. In my affidavit, I have categorically stated that my father belonged to the Assam and my mother is from the West Bengal. And I did my schooling from West Bengal. But at that time, a certificate was issued to me and inadvertently or mistakenly, it was placed in service. But when I came to know that the Kuta communities are not considered as OBC in Assam, then I have submitted the certificate which is issued by the authorities of Assam as it was issued in the year of 2005. So, Lordship, this certificate was also verified by the authority and the deputy commissioner.
Can you belong to 2 communities?
No. I am that part
The
is
question will come to if you even accept your submission that your father was from Assam, mother from West Bengal, and you have a certificate of West Bengal, which treats you as an OBC in West Bengal, and that particular category is the general category in Assam. You say that there was some mistake there. You have another certificate from Assam of the year 2005, which recognizes you to be an OBC of Assam. Now, there is a distinction between the 2 communities.
No, I am not taking any advantage from the certificate as I am the permanent resident of the Assam. So I am not taking any advantage as provided by the authorities of West Bengal. That is admitted position.
And what about your wavering conduct in so far as applying for similar posts in other colleges? You declare yourself to be an unreserved category. And there are, on record, he has brought some materials on record which would show that there is inconsistency in your conduct. At times you declare yourself to be unreserved. At times you depend upon a certificate of West Bengal. And in this present case, from the affidavit of the state, it transpires that 2005 certificate was also there, which the principal has introduced by communication to the director. which was acted upon, therefore you are given the benefit. How do you explain your conduct?
Yes, Lordship. That application my friend is referring, I did not appear there for interview.
Hmm?
In other college, I did not.
No, not are you disowning the application? Not appearing is another consequence, another connotation. Are you disowning that you have applied? This is your application. You're not disowning.
No, that is I'm telling Lordship, that application was sent. That the stated that I did not appear because I thought that I will not be selected because I did not produce the relevant documents. But my issue is that what I have done in Pandit Deendayal Upadhyay College in Katnichara, my entire case is confined here. And my act, what I have declared in my application.
The Mazumdar, he is trying to develop a case, and to develop the case, he has brought the contemporaneous material to show that your conduct is wavering. It is not consistent. You have to explain that. He has discharged his burden. The onus now comes upon you to have a reasonable explanation. Simply by saying that I did not opt for going for the interview, that may not be the answer. Unless you say that this application I never made. That is not your stance.
I have never stated in my petition that I have applied.
No, that is his stance. Now he had got the chance to rebut. You have not rebutted. You have not said that I have not applied for. Now you are submitting that I did not go for the interview. But in the declaration, you have said that you belong to an unreserved category.
Lordship, may peruse my affidavit. Nowhere I have admitted.
See, even evasive denial is no denial. Mazumdar,
And
making a
Lordship,
submission in the court, don't make this kind of submission. CPC says that even an evasive denial is no denial. You are saying that you are not admitting. Does it mean that you have denied? Denial has to be specific.
I have not mentioned anything that is implied that I have not admitted.
No, we will appreciate your argument. You are saying that you are confining your case since it is pertaining to Pandit Deendayal College.
Since it is a review petition, so I am confining whatever point he
That
has
is okay,
raised.
but okay, then proceed.
That the only issue is raised the late submission. That I have explained and I have submitted.
Anything else?
And the Lordship is another issue. Page 79 of the affidavit which is submitted by the state respondent. 79. That my learned friend is legal.
This Kajing Yaying you are not referring to Arunachal case context of this.
That is that I forgotten, Lordship. The decision is passed. Your Lordship.
No, what is the ruling? We do not know. We have forgotten.
This is the case where also the Tejpal Singh case also referred.
Which paragraph
Yeah.
now tell us? Is this reported? Not reported.
It is not reported, Lord.
Nothing. Kajing Yaying was the previous.
But if this paragraph number 9 may be useful.
Para 9. Yes.
So far as the WPC 222 FE 2018 is concerned, the learned council has drawn the attention of this court to the list of enclosure attached to the application filed in response to the advertisement wherein the SP certificate has been specifically mentioned. The pleadings wherein ST certificate, the pleadings were more specifically the paragraph number 4 and 12, the writ petition have been relied upon wherein it has been specifically conducted that such certificate was given along with the application to the learned council submits that as laid down by the division bench of the Delhi High Court as well as in the Honorable Apex Court, the submission of ST certificate cannot be held to be fatal. The late submission of the ST certificate cannot be held in fatal, and it is regarded that there is no dispute to the fact that the petitioners belonging to the ST category. The learned council also makes an alternative submission that even assuming that such certificate was not furnished along with the application, the candidate could not have been rejected. The candidature could not have been rejected at the best candidate who could have treated
No,
in the
and at
category
best,
of
no,
undeserved.
not the best, and at best, the candidate should have been, could have been treated as
They could have been treated in the category of
unreserved.
unreserved. However, that has not been done with the reflex. But I'm not relying on that part. I'm just highlighting that the Tejpal Singh case was also referred because it is a different case. It may not cover my case also. Now, Lordship, page number 79 of the review petition.
79.
79.
Yes.
Lordship. Paragraph number 5. The deponent begs to state that the principal Pandit Deendayal Upadhyay Government Model College, Katlichora, Hailakandi submitted a proposal by letter number so and so, Assistant Professor and so, Department of Education, desired for OBC, MOBC as per the RP number so and so in respect of the selected candidate, Dr. Mr. Sarwar Jahan, OBC, NAT, PhD. After observation of the proposal, it is seen that the OBC category caste certificate of Mr. Sarwar Jahan is from West Bengal, that is outside of the state. It is further back to state that in application for the post of assistant professor, the petitioner fill up his present and permanent address as Bordurai, Gwalipar Bazar, PS, Hailakandi district, so and Hailakandi pin so and so. The deponent begs to state that the principal of the college has informed by office letter number so and so dated so and so that the post is reserved for OBC, MOBC category, and the selected candidate, Dr. Mr. Muhammad Sarwar Jahan, is having OBC certificate from the state of West Bengal, which is treated as general category in the state of Assam, and also informed that the proposal submitted by letter dated so and so is regretted for appointment as assistant professor in the Department of Education under the reserved category for OBC, MOBC category of the college, and request him to re-advertise the post immediately as per the latest government office memorandum. The deponent begs to state that in response to the letter dated 22/2/2021, the principal Deendayal Upadhyay Government Model College, Katlichora, Hailakandi, has addressed a letter by letter number so and so to this directorate in enclosing an OBC certificate of Muhammad Sarwar Jahan from the state of Assam by office of the chairman of subdivisional OBC Development Board, Karimganj, by serial number so and so dated so and so, which was countersigned by the Deputy Commissioner, Karimganj, and also stated at the time of applying for the post of Mr. Sarwar Jahan had submitted permanent resident certificate of Assam. This is important, Lord. And next paragraph, that paragraph number 8. The deponent begs to state that the directorate has issued a letter addressed to the Deputy Commissioner Karimganj for authentication of the OBC certificate by the office letter dated so and so. The Assistant Commissioner for Deputy Commissioner Karimganj has submitted authentication regarding clarification of the case of the caste OBC by the letter dated so and so. Yes, the OBC caste certificate issued from this office by number 462 dated 23/8/2005. Mr. Sarwar Jahan, son of Mr. Abdul Rasid and Srimati Keswar Jahan, village Sanigram, post office Dalangati, district Karimganj, was verified through the circle officer Karimganj, and it reveals from the report of the circle officer Karimganj submitted by number KC 30-2017-460 dated 9 September 2021 that Mr. Sarwar Jahan and his family member are from OBC category of the subcaste Julha. The Julha caste is a OBC in Assam, Lordship. Lordship will find it is in the annex of my affidavit, page number 170 of my affidavit. That Lordship, it is a central list of OBC for the state of Assam. The entry number 24, page number 171.
Entry 24.
24, page number 171.
Yes.
Tea garden laborers, tea garden tribes, ex-tea garden laborers and ex-tea garden tribes as listed below. And the page 172, serial number 40.
The number
Serial number 40, Lordship.
40.
40. That the Julhas are the OBC notified by the competent authority.
Tulha. Okay.
And regarding Lordship, regarding my social status, there is no doubt. The only issue is the late submission that the review petitioner have raised, and that I have explained. Another issue, Lordship. When as in their affidavit, the state director has stated, is relying on that when the valid certificate was not produced before them, they instructed the principal for re-advertisement. This is that my friend is highlighting.
No, I don't see.
179.
Okay.
79.
79. Please read paragraph 6 again.
79.
Yes, paragraph 6.
I'm coming. 79. Paragraph 6.
Yes.
The deponent begs to state that
Deponent means the director.
Right.
Deponent is the director.
and when the
No, no, read it.
yes,
Read this.
yes,
Read this, then you make a sub.
the deponent begs to state that the principal of the college has informed by his office letter number so and so that the post is reserved for OBC, MOBC category and selected candidate Dr. Mr. Muhammad Sarwar Jahan is having OBC certificate from the state which is treated as general category in the state of Assam, and also informed that the proposal submitted by its letter so and so is regretted for appointment as the assistant professor in the Department of Education desired for the OBC, MOBC category of the college, and request him to re-advertise the post immediately as per the God office memorandum.
This request had come from the principal.
No, it was from the director.
Now, this letter is by whom? 22/2/2021.
Director.
Yes, it was director.
No, no. Read this again. The deponent, the principal of the college has informed.
Yes, by letter dated 22/2/2021 that the post is reserved
Has
for
informed or was informed. What
Was it?
if he was informed? What is this kind of thing? Where is this letter? Where is this 22?
It is not annexed.
I think it's there.
It is not annexed. No, it is in record. Record is there. Is not there, my lord, the subsequent letter is there from. Principal letter is there, my lord, the director letter is not, my lord, it is in record.
Understood. It should be has, I think. Was. It should not be has, it should be was, I think. And he responded on 22/3. Correct?
Yes, ma'am.
Principal response was of 22/3.
Yes, yes, March, his director letter, February, my lord, 22.
That is
And-
at page 84.
Yes. His principal letter is 84, my lord, 84.
22/3, 21.
Yes, my lord, this principal letter.
84.
Yes, ma'am. And my lord, this letter, my lord.
You have the director's letter? Oh, we'll look. Yes. Two, 20. Okay.
So Lordship, that principle and the basic, which is laid down by the Honorable Apex Court, considering that principle, that the late submission of the caste certificate is not a ground to reject the candidature of any OBC candidate, the Deputy Commissioner was instructed to verify the authenticity of the caste certificate. Accordingly, he has verified. And the authority, appointing authority accordingly satisfied, yes, that applicant is belong to the OBC category and he has been appointed. And it is an in-house exercise. Lordship, that review petitioner is not at all, this in-house exercise does not resulted, he is not all affected by this in-house exercise. I am assuming, Lordship, not admitting, assuming that the post has been re-advertised, assuming, not admitting. Then how he is entitled to be appointed? As per this letter that they are going to re-advertise, assuming, not admitting, that he cannot be appointed because his prayer is that he has to be appointed in the post as an assistant professor. And here the director is telling, no, I will not appoint you. I will not, I will not appoint anybody. I am going to re-advertise.
Yes, that's different.
So it does not result by no way he is not affected by this communication, and it is in-house communication. It has not been also put under challenge in any manner, no one. So Lordship,
In the selection, what was the outcome in the interstate merit?
in merit I stood first.
What was the difference of mark?
That
How many
what is
candidates
there,
are there?
I cannot.
For OBC?
My three candidate, my lord, so far I'm stated, my lord, my position was second, my lord. Might become second person, my lord. Only my lord, this intentionally, I mean, all documents.
And Lordship, another point is, as per the latest office memorandum, no panel list is prepared. Only one candidate is selected.
That thing is different. my lord.
I'm coming, I will get the opportunity.
That thing is totally not in with the case,
So-
no? Yes.
No,
Related to-
somehow it has to result in prejudice to the review petitioner that this in-house exercise has resulted some prejudice to him so that he is agreed. But it is not there. In fact, Lordship, now he is at 41. It is an OBC category. 41 plus almost in affidavit it was filed 1 year ago. At that time he was 41. He is also not entitled to be appointed. His bar is there.
Well, that submission must not related.
Come to it.
So Lordship, I am just concluding that My submission is the first only question, the issue which is raised, that the late submission, it is covered because the OBC candidate are entitled to submit the caste certificate on late submission. And another issue that I have raised, Lordship, the maintainability of the review petition. Nothing is identified that there is some infirmities, irregularities while making the decision, and and which come within the ambit of the review code. There is nothing. And the liberty, this is most important. While submitting in the division bench, yes, I have raised the point before the single judge, but he overlooked, he did not consider. And before coming back to this court, position is changed. No, I did not raise this point. So these are the fact, Lordship, clear incidents of the misleading the court. This is my submission.
You're for the director.
Lordship.
Yes.
Next, your Lordship, as per Lordship's direction, we have received the original record already submitted to the honorable court. Here, Lordship, we have filed affidavit in the division bench, Lordship, that affidavit is in the record, Lordship. Here, the bone of contention is regarding the Lordship, the OBC certificate. Here, Lordship has to decide the issue, Lordship, whether it should be treated as a late submission or otherwise, Lordship. And because, Lordship, regarding late submission, the law is well settled by the honorable apex court as well as my lord judgment also there, Lordship. It was delivered probably in February, month of February, Lordship has delivered one judgment, Lordship. Regarding late submission, Lordship, the law is well settled. Now, Lordship has to decide, Lordship, whether this should be treated as a late submission or otherwise, Lordship. Because at the point of submission of the application, Lordship, he has submitted a certificate from the state of West Bengal. And it was reverted back, the recommendation was reverted back by the director, Lordship, to the respondent police authority to direct to redo the exercise, Lordship. After that, they have again submitted a proposal by enacting a document regarding the OBC certificate in respect to the state of Assam, Lordship. Now, Lordship has to decide one issue, Lordship, whether it should be treated as a late submission or, Lordship, or otherwise. Because, Lordship, he has submitted the OBC certificate in the state of West Bengal at the time of, Lordship, submission of the application form. It is in the record, Lordship. And on the basis of that, again they have sent the proposal, Lordship. On the basis of that proposal, Lordship, verification was done. On the basis of that, we have given him appointment, Lordship. That appointment is rightly or wrongly, I cannot comment it, Lordship, because appointment was done by the authority, Lordship. It will be decided by my lord that whether that appointment should be done or not, Lordship. And Lordship has to decide whether that particular certificate was the state of Assam, it should be treated as a late submission or not. My lord, this is my submission, Lord. Lordship has to decide whether that.
You are only proposing the question. You're not assisting the court.
Lordship.
What do you say?
Lordship, I am saying that my submission is that, Lordship, at the time of submission of the application, that
These are the questions of fact. We know those.
Lordship,
That at the time of filing of application, there was a certificate of West Bengal, there was a re-verification exercise, the certificate of Assam crept in, you made the authentication process, it turned out to be correct.
record reflects that, Lordship.
Now tell us what
My point of view,
what
Lordship,
is the reports available to the
Lordship,
in exercise of review power?
in exercise of the review power, review whether that particular fact was at the time of hearing that particular fact was Lordship not placed before the honorable court, Lordship. Record was also not placed before the honorable court, Lordship. And Lordship, we have also not filed affidavit in this case, Lordship. So that particular fact was not before the honorable court.
See, to be very transparent,
Lordship.
the affidavit of the government came into picture in the appellate stage.
Appellate stage, Lordship.
But that affidavit does not end in paragraph 6 and 7.
Lordship. And
6
other,
and 7 says
Lordship.
that yes, the certificate relied upon by the respondent state pertains to another state.
Lordship.
That is not the issue, but the caste of that state is treated as a general caste.
General caste
So you go for re-advertisement.
Lordship.
That was responded to by the principal, saying that there is another certificate of
Lordship.
2005
Lordship.
pertaining to the state of Assam, which affirms that the respondent
Belongs
state
to the
belongs to the OBC category.
Lordship.
You had done an authentication exercise.
Lordship.
certificate was found to be authentic. His caste as OBC is, as on today, is not put to check.
Lordship, Lordship.
That is not the subject matter of check.
Not a
The
subject matter of
question
challenge.
which now boils down is whether a caste certificate which was existing but was not put with the application and had come into the surface only much after the date of the,
Lordship,
whether that can be taken into consideration.
Lordship. That regarding late submission per law is well settled, Lordship. Whether Lordship has decided it should be late submission or not, Lordship. That point is clear. Because Lordship, at the time of submission of the
No, see, there are
Lordship,
there is a distinction.
Lordship,
Suppose there's a last date for applying for a particular post.
Yes.
You need to be a PhD or a graduate.
Lordship, Lordship.
You obtained your graduation after the last date, but you say that I obtained the graduation before the consideration, so allow me to.
Yes.
Court has said that no.
Lordship.
But here is a case where caste, you belong to a particular caste on your birth.
Yes.
You not acquire.
Lordship,
It's not that some qualification you give an exam,
Lordship, Lordship.
results are awaited.
Lordship, Lordship.
So only by the fact that there was a late submission in a caste certificate, which is distinguishable from any other certificate, which you can acquire.
I am not in this on that point, Lordship. Regarding caste Lordship, there is no doubt, Lordship.
That is exactly the point.
Yeah.
Whether if you are not raising a dispute,
Not regarding that point, we have not any dispute is also there, record is also there, Lordship. Only thing is that, Lordship, the petitioner submitted a certificate, OBC certificate from the state of West Bengal at the time of submission of the Lordship application. At the relevant point of time, whether he has that particular certificate, yes or not, I don't know, Lordship.
no, 2005 in your own affidavit, you have
2005,
said
he has the certificate.
2005 certificate you are not denying.
We are not denying because authentication was also done,
Done.
Lordship. That certificate was also not put to silence before any the authority, Lordship. And even they have silenced it as per Honorable Episode Kumari Patel, that should be go by the committee, Lordship. That was also not done here, Lordship. Regarding that particular 2005 certificate, we have,
In
Lordship,
fact, 2005 certificate is not the subject matter of
subject
dispute.
matter of the
Of
dispute.
dispute.
Only dispute is that, Lordship, whether
Late
Yeah.
submission.
Lordship. Late submission part is Lordship, I am not saying. Whether
No,
that at the time of submission of the application, there was a OBC certificate, Lordship. Whether it should be treated as a late submission, the letter certificate which was submitted by the petitioner, it should be treated as a late submission of the OBC certificate or not.
Yes.
Because, Lordship, at the relevant point of time, when the application for the particular push was, Lordship, submitted by the
Now there,
petitioner,
Mr. Gogoi, another question would
Lordship.
arise.
Lordship,
A certificate obtained
Lordship.
after the last date is one connotation, has another connotation. An existing certificate will have another meaning.
Another meaning.
Now, the Supreme Court in the cases referred has said that so far as caste is concerned, it is only an affirmation by a certificate.
Lordship, Lordship.
Caste
That
you
is by
not-
birth,
is
Lordship.
by birth.
By birth, it's a settled
It
position
is
of the
not
law.
some like a qualification acquired
Lordship.
in course of time.
Regarding that particular point, I have no any grievance, Lordship. I have no, I have nothing,
We'll come to
I have nothing to submit anything, Lordship. But I am only indicate that, Lordship, at the time of submission of the application, Lordship, he has already submitted the.
But Mazumdar may be right in contending that this point was raised, was not considered. That was not before us.
That was not before the honorable.
It came in the division mentioned in the
It was in the, Lordship, appellate space, Lordship.
appellate stage.
Appellate space, Lordship. That point was not argued before the honorable, my lords, before the my
Would
lord,
not have been.
Lordship. And that particular record was also not called in the Lordship, read to this.
So that he may be correct in saying that liberty granted should be read in context of the submission made that it was
Lordship.
argued and not considered. That
Lordship.
argument could not have been made.
But that particular argument was not placed before the honorable court. Lordship. Regarding that late submission part also, regarding that submission of that particular certificate also, that was not argued before the honorable court. Lordship. I am only saying that on the basis of the record, Lordship may, whether it is a review jurisdiction or not. Lordship.
Yes, sir, you complete your argument then. Right. 5 minutes.
Yes, ma'am. My only point, my lord, the basing case, my lord, this I'm at that time could not place, my lord. Your conclusion part, my lord, says, my lord, this
Which case?
BIR, Bir Singh versus Delhi Jal Board, my lord.
Yes.
My lord, I already have submitted before the honorable court, my 2018 10SCC, my lord. Here says, in so far the state are, I agree with the majority view that a person who is recognized as a member of scheduled caste or scheduled tribe in original state, he will be entitled all benefit of reservation of the Constitution of India or that state only. That state only, and not the other state, union territory not entitled or benefit or reserved in the migrated state and union
No,
territory.
he has a certificate from Assam.
No, my lord, this is, my lord, he submitted, my point, my lord, whether he is OBC from West Bengal, my submission report. Then that, so that, my lord, the certificate is produced, he applied, not only one college, my lord, in other college also, my lord, as per record is before, my lord. So, my lord, in person, my lord, is when he was done, it was indicated that you will be treated as a general, then only, my lord, he submitted, my lord. That also, my lord, so far this Zolha and the Kotha, a person from the OBC, my lord, I no doubt he is OBC, but a person from the OBC from West Bengal, when he coming from to Assam, he cannot be converted to Zolha. And so far, Zola,
No,
yes.
that 2005 certificate, that is now the subject matter.
No, I understand well, but he might have submitted, so I'm before them. But this question is, my lord, this that
No,
my lord,
Beer Singh is on another footing. Beer Singh says that certificate of one state cannot.
yes, my lord, yes,
But
yeah.
he's got a certificate from state of Assam.
No, my lord, this
That certificate
my lord,
is not
a
put to
person, my
side.
lord, when my lord, so far his case is my lord, he belatedly submitted. But when he submitted the
That
certificate,
is the only point.
yes, man, he's subsequently submitted, he OBC. I am no doubt he is OBC, but when submitting the certificate at the date of filing the application, before the college, he submitted so far his knowledge, if suppose only one college, one college, he's submitted this certificate from this West Bengal, not the other, but at particular time he submitted all college, the West Bengal certificate, So this the intention, if intention, suppose he is not placed, he submitted in right OBC only. He is not submitted this certificate. Then he may be submitted belated certificate. Here he has submitted a certificate, my lord. This is in the record, my lord. And it was detected. He was treated as general candidate. It was informed the principal. Then only subsequent, my lord, this after mine, my lord, they produced, my lord. And so far, this in same government college in Assam, my lord. Not if it is the different state of assembly is different, but in Borkola, in Kasarmaya, the same government college. Dindwali is a government college, my lord, and Borkola, this is also government college, my lord. In same college, he submitted the certificate from West Bengal, my lord. And my lord, the West Bengal certificate, my lord, so far my friend submitted, my lord, it was not his in childhood, my lord. It was 2012. The other certificate in 2005 is subsequently 2012. He said this certificate. It is I have annexed, my lord. So these are the, my lord, is completely intentional, my lord. So this it is not that this he is not aware of. The subsequent certificate, this which produced, it was 2012. It is in record.
Where are the two certificates?
Yes, my lord.
That's West Bengal certificate and the.
And 85 in my review, my lord, this my lord, review petition, my lord. It is his original certificate, Zola Assam certificate, my lord.
And West Bengal?
Yes, my lord, I am getting. And West Bengal certificate, my lord, is additional affiliate 150, page 150, my lord. My lord, is 2012, he is major, my lord. And 2005, he's probably he's maybe minor, my lord.
Ah.
I don't.
And page 180?
My lord, 85, my lord, is certificate
West
from
Bengal, West Bengal?
West Bengal 150, my lord.
150.
Last, my lord. It was issued, my lord, 3/8/2012. And control sign, my lord, 2020, my lord. District magistrate, my lord, and deputy collector sign on 2020, my lord. And 20, my lord, advertisement was made, my lord.
Yes, where is the class?
My lord,
Kotha.
Kotha, the Kotha, West Bengal. Kotha, my lord, they are Uiphar, my lord. And my Jolha, my lord, they are never in the Muslim community, there is no Jolha, my lord. So for my friend, read before his honorable court, my lord, I am reading again, my lord. His affidavit, my lord, PS 171.
Kotha.
Kotha, my lord, how it is if in Assam there is no Kotha? In only West Bengal there is Kotha communities there. And my lord, and so far 171 page, my learned friend affidavit, my lord. I'm not disputing he's not OBC. He's OBC, my lord. The other judgment submitted, my lord, regarding OBC and SC, my lord. Those are vibrant OBC. He's vibrant OBC in Kotha in West Bengal, my lord. I'm not disputing that one. I'm not disputing that. I'm disputing that the man from the West Bengal OBC Kotha, my lord, how if he will be in different state, he will be treated. If he's treated as the Kotha in Assam, then also different thing. But Kotha, there is no OBC in Assam. My lord. And so for page 171, your lordship may turn.
171.
Yes, my lord. He's affidavit, my lord.
Yes.
So for serial number 24.
Yes.
Tea garden laborers, tea garden tribes, ex-tea garden laborers, ex-tea garden tribes, as listed below. They are those, my lord, including my lord, Porti Zolha, my lord, they are tea garden OBC. No Muslim, my lord. Muslim OBC is, my lord, dear, my lord.
Where?
Yes, I'm. Muslim, my lord, page 173. Maimal, Maria, last 27-28. Zolha cannot be a Muslim community from my lord. This is also my lord. I'm not challenging that part, but the person, my lord, is producing the certificate in not only one college, in other colleges, my lord, in same set of Assam.
Lordship, one more submission.
One second. Okay. Sir, what you are rejoining? You're closing this. Anything else?
No, I have one. And so for my lord, paragraph PS, my lord, is 11, my lord. My learned can indicate that, my lord, this so for paragraph 18. The fact in circumstances stated, page 10, my lord, of my review petition.
Yes.
The above Bex stated review petition is following grounds among the others. The further they come to know that filing the petition respondent about the filing affidavit innovation that the respondent 6 submitted OBC certificate from West Bengal. My lord, this in my submission was his West Bengal, but it is confirmed that he is from West Bengal. It is submitted. I'm from West Bengal at the time of submission of application, but because I filed several applications RTI, my lord, it was not provided, my lord. But the principle of the college, in great prison, I have annexed all the documents, my lord. So it was not annexed, my lord, not my lord, supplied to me, my lord. At the time of submission application, which was subsequently sent by the college authority to the for appointment of the respondent 6, with a proposal also answered. But on 22/3 to the principal of the college submitted another caste certificate. It is, my lord, from the so how this is only affidavit. This is subsequent fact, my lord. The principal of the college submitted another certificate. This respondent authority cannot accept the document. This, my lord, if there is a relaxation, my lord, in advertisement, my lord, then the respondent authority may accept the subsequent documents, my lord. He may be, my lord, even, my lord, if he is OBC, my lord. In other judgment, my lord, I have submitted the APSC case of Assam, my lord. He is locomotory handicap, my lord, but he is not produced the certificate. But apex court says no, because subsequent documents cannot be accepted, my lord. If there is no relaxation, this is a violation of Article 14. And the national authority cannot accept the documents after the date of submission. Here, my lord, is his date, my lord, he is originally submitted my documents in other state. Now, my lord, he is submitting, my lord, is when it was indicated. Not if not indicated, my lord, by the authority, he is not treated as general. He never submitted the documents. The other cases, my lord, is they are, my lord, OBC, my lord. Not submitting the certificate, that thing is different. Here, facts is completely different. If the person is already filed a certificate from OBC from West Bengal, when he is indicated you are OBC from West, he after making mine, the principal favoring then he will submit it. This thing is different. So I am not on his subsequent certificate. I'm certificate, it is very much clear. Deputy collector from the West Bengal, although itself he understands this his certificate. This is 2012, my lord. He is not in that time his major, my lord. So he says, well, I have another certificate, but it's some certificate is subsequent, then thing is different. But when 2022, when he applied this course, he obtained the certificate. This one, my lord. So, my lord, all this not does I am in my repetition also, my lord, in paragraph 18, my lord, page 31.
Yes.
Then the petitioner stated respondent 7, not belonging to OBC category state of Assam. Therefore, he cannot be considered the authority as well as state person for appointment against the post of assistant professor of education, which reserved for the candidate belongs to OBC Assam. Respondent 6 belongs to Malda, so not permanent resident. After marital relation, he is staying on so and so where he is working near so and so. Therefore, respondent 7A is not a permanent resident as such. OBC status or person in the state of Assam for purpose of employment cannot be enjoy a person from coming from other state. The action of respondent by which the respondent.
Yes.
So well, this was my in read petition, well, but when the in stay petition was hard, my lord, it is only hard the stay petition, my lord. So my lord, when because of non-filing of the affidavit from the opposition from the state government, my lord, all this all facts not came before this honorable court. So this honorable court pass order, my lord, and the date, my lord, is because once, my lord, is if he suppose a particular date, my lord, if he's not filed this documents, my lord, if he suppose he genuinely, my lord, is OBC, my lord, same OBC. West Bengal is OBC Zola, in Assam also OBC Zola. That thing is different. Here OBC Zola from the West Bengal is not treated as a OBC. So my lord, this cannot be, my lord. So Bir Singh also says, my lord, he is enjoying this benefit and he cannot deprive the other OBC candidate from Assam, my lord. This is also my humble submission before honorable court, my lord. So for my lord, re-advertisement part of concern, here now there is no link, my lord. If suppose the authority re-advertisement, that thing is will be completely different. So my friend submit like this. Re-advertisement I will not get. So this should not be, my lord, the interpret this honorable court. That is not our case, my lord. Our case is very limited case, my lord. A person, he not only one case, in other court also he applied this same certificate from West Bengal. And subsequently, he was indicated you are treated as general, then only he this certificate made this.
Okay, we have heard you. Yes, anything, just a minute. We have heard you otherwise. Anything?
Just, I will not make elaborate submission. The conduct of a person, past conduct of a person, suppose that my learned friend is referring in some other college, I have applied for, they have stated. But it is not only that college, I have applied so many colleges. At least 10 to 20 colleges, different department also. So the past conduct of the person cannot be mixed up when a certain issue is raised before the court. And I am not also admitting that past conduct. And the second issue is that my friend is repeatedly trying to establish that I am from the state of the West Bengal. But if a voter ID card that has been annexed.
We are not citing those. Whether you're from West Bengal, that's not
It is not
relevant.
matter.
They
Yes,
are only a relevancy of the certificate.
And-
That will decide.
and issue is that the certificate, if the authenticity of any certificate is a disputed fact regarding the caste certificate, it has to be verified by the concerned authority. This is the settled position of law. And the West Bengal certificate, which is being, as per his version, which is being treated in Assam. All right, these communities are.
No, how do you become two communities? One in Kota, one in Jolha.
I'm coming, Lordship. I am not belong to the two communities. And issue is that I have explained in my affidavit also that I'm very much honest of my submission. My mother is from West Bengal. That is correct. My father is a permanent resident of the Barak Valley, Assam. So I belong to the state of Assam. According to the
No,
certificate.
your permanent residency is not an issue. To your caste, you belong to two castes.
No, I belong to one caste, Julha. And Lordship, this is a very big issue that a person, suppose that a person and his mother is Brahmin, his father is non-Brahmin.
No, we are not going to that issue. It is your certificate. You have produced one certificate
So,
saying that you are Kota, one certificate you are Jolha.
The Julha is an authentic certificate. It is very.
Kota is not authentic.
It is not authentic. What that is why I am trying to explain.
But it is you have submitted.
That is why I am trying to explain.
You have not disowned that certificate.
No, that is why I am trying to explain that my father is belong to the Lordship. This is a very vital question as my line.
Okay, we are not going to enter again. We are not going to enter into the ticket. We are confining ourselves to a review. Yes, heard SK Medi, Planet Council for the review applicant. Also heard the FZ Mazumdar, Planet Council for This for number
Six.
whereas the department is represented by Sri K. Gogoi, the standing counsel. The arguments are completed. The judgment is reserved. Sri Gogoi has also produced the original record of the case, which produced the original. Welcome.
Judgment reserved, no? Judgment reserved.
Yes. Yes. Right.
May I please lordship, my lord. We have challenged the improved order, that is page 43, my lord. Now here, my lord, one thing is this, on the last occasion, some interim protection was given.
Service is completed. Service is complete.
Service complete.
Yes.
Now thing is this, my lord, when the interim protection was given, at that time, that was fixed on 26/7.
Hmm.
So it has not yet come. So we got nothing. We went to deposit rupees 30,000 as ordered by the Honorable High Court.
Right.
But the case is fixed on 26/7. So Planet just said that you deposit it on the debt fix.
Okay.
So I think after
We'll have a
26,
date after 26.
interim may kindly continue because we have
Yes.
got nothing from the interim protection.
Yes. Take care for whom?
And for the wife, that's one.
Or
Only one.
Free MU. Somebody else had appeared over
No, madam.
on the earlier occasion. Mr. Mahmood?
No.
Okay,
No,
MU
name is wrongly written.
MU Ahmed has been written.
Yes, it sometimes happens.
Heard Free MU Mahmood Learned Counsel for the petition. Also heard Free P. Saikit Learned Counsel for the respondent. Free Mahmood, the Learned Counsel, has submitted that to by order date 28/6/2020. This court had passed an interim order subject payment of rupees 30,000 before the court of the additional district judge within bracket FPC bracket close North Salmara, Bhaipur, he has submitted that the date fixed for the state court is only 26/7/2023.
26/7.
He accordingly pays for some praise for an adjournment of this case to be fixed on a date after 26/7.
Yes.
2023, on which date, the payment, as directed, can be deposited. In view of the above submission, matters can adjourn to be listed. To fix the date or after 3 weeks, to be listed on 16th of August. 16th of August 2023. The interim order passed earlier shall continue till the next date fixed, subject to the condition of making the payment as aforesaid on the next date before and on the next date fixed by the court below, which is 26/7/2020.
All right. Service is not complete. The rejections were to take steps to restart post and Dusty was also permitted, but we have taken steps to restart post continue.
Dusty is permitted till the 1 week. You have not taken Dusty.
We have not taken the.
Take the Dusty.
In any way, tomorrow the date is fixed before the learned tribunal. So here is a case wherein an attachment was passed without hearing the petitioners, my lord. We have assailed that, and that was stayed. And tomorrow is the date. So if
There is a stay order. There was a direction to serve Dusty. You have not taken Dusty. Why?
Dusty is also permitted, my lord. It was
Also
steps on restart post by
also permitting Dusty means there is an urgency
in
and there is a stay order.
yes,
So you need to inform them personally. Okay, so take the Dusty immediately.
yes.
We did
Because
do
of these vacations, my lord, could not be taken.
When was the order passed?
4/7, my lord.
4/7.
Vacation.
For vacation, Dusty is not permissible.
No, no, because of this vacation, my lord.
Vacation, you
There
can
was
come
some
to the court to
miscommunication.
move.
Some
Can come to the
miscommunication.
court to move the petition. You cannot take
No,
Dusty
my
service.
lord, there was some miscommunication, my lord.
Third PA, the direct conflict for the petitioners. Office note dated 13/7/2023 reflect that notice by registered post with AD was issued on 12/7/2023. However, steps for Dusty service have not been taken by the petitioner. Redas, conflict submit that due to some difficulties, inadvertent difficulties, steps by Dusty service, steps by Dusty could not be taken, and he prays for a further opportunity to take Dusty service. Not bad. He further submit that the interim order that an interim order was passed. That interim order passed on 4/7/2023. It was till the returnable date, that is today, and the next date is fixed tomorrow.
Tomorrow.
Before the year. He accordingly prays for extension of the interim. After hearing, this court is of the opinion that interest of justice would be served if a further opportunity is granted to the petitioner to take justice service. Accordingly, petitioners are directed to take steps by justice service upon how many respondents? Upon the respondents.
3 respondents.
Upon the respondents.
One
Fixing the next date as 21st of August. It is needless to mention that such justice has to be rooted through the registry of this court, and in the notice to accompany the Dusty, the next date fixed, that is 21/8/2020, be reflected. Court of- Balancing the equities, comma, is further directed at the interim order passed earlier
On
and
4/7,
extended till the next day.
interim order dated 4/7.
That's right.
I'm obliged.
Interim order dated 4/7/2020 has extended to the next.
I'm deeply obliged.
Take steps by tomorrow. Yes. Justice service is directed above. A step for justice service is directed above. Be taken by. Mr. Das, he had one line. Liberty, no, liberty. The Senate counsel for the petitioners are also directed to inform about the proceeding.
Yes, tomorrow.
Report to the Senate counsel for the contesting respondents as the date is fixed before the learned DRT tomorrow.
I'm deeply.
IA for? IA for?
100%. Yes.
No, IA for what?
I was for the substitution of the sole appellant.
Appellant has passed away.
Yes.
Is it
And,
filed it in time?
It was on time, Lordship. The problem is, Lordship, that the suit, the civil judge one, it has been dismissed for default. On the earlier occasions, they were directed to obtain certified copies and produce it in the form of an additional affidavit. But as per their instruction, they haven't got the certified copy.
No.
Till now, my lord,
Yes.
I didn't get the certificate till now. I applied 6/7/2003.
This TRP is for what?
Money suit.
The TRP is for what purpose?
There,
246/2010.
What is the purpose of filing this TRP? Against which order?
Yes, money suit.
Understood, but you're aggrieved by what? Why have you come to the High Court by means of the TRP?
For relief.
What relief? Which order?
Yes.
You know the fact. Don't just come to this court like this. You cannot assist. You still will read the file.
No, my lord.
You cannot assist the court.
No, we can't-
What is the point of having
we
a
have
counsel?
we have not get any documents till now.
We are not on that. Why have you come to the High Court? Why are you aggrieved? Which order by the trial court? You have filed this case CRP 332 of 2017.
My lord.
Against which order? What is the cause of action? Yes, Mr. Dev.
Lordship, they have, in the suit, they have preferred an application under Order 6/17 for
For
an
amendment.
amendment.
They are the plaintiff.
They are the plaintiff. I am for the defendant number one. So
That has been rejected.
yes, that has been rejected.
Against rejection of the amendment prayer, they have come before this court. CRP.
And
pending.
against that, they have obtained a stay on the very first day, but since they have not instructed the lower court about the stay order and all, the suit proceeded accordingly and it was dismissed for default.
Oh, there was a stay order.
Yes. It was dismissed in the year 2018. So on the earlier occasion.
Have you taken steps for restoration of the suit?
No.
Why? And if you don't apprise the court that is stay order, court will definitely proceed. And this is of 17.
Yes.
What was the suit for? Suit for? Suit for?
Suit for the Lordship, recovery of an amount of rupees 19 lakhs.
Recovery suit.
Yes, and it was basically a sale agreement between the plaintiff and the defendant.
Third, three RP the Senate counsel for the applicant petitioner. who by means of this application has prayed for substitution of the petitioner who has passed away in the meantime. So, parent, Sri Dekha, the learned counsel for the respondent, however, has informed this court that the suit has in the meantime been dismissed for default. And no steps have been taken for restoration of this. And therefore, there may not be any live cause of action in this present petition. He has, however, fairly submitted that while entertaining this petition, comma, this court has passed an order dated 6/11/17 directing that until further orders, comma, further proceedings in the money suit 246 of 2010 pending in the court of the learned civil judge number 1, comma, Kamrup, within bracket M, shall remain stayed, full stop. He further submits that it appears that the aforesaid interim order was not brought to the knowledge of the learned court below, as a result of which, comma, the suit has proceeded and was ultimately which had culminated with an order of dismissal for non-participation. Under those facts and circumstances, this court is of the view that an opportunity be granted to petition applicant to take appropriate steps as deemed fit in law. At least after 4 weeks to enable the applicant to take necessary steps. Take steps, get the suit restored, file this, furnish a copy of the interim order before the court.
Thank you, madam.
As per office note, my lord, always upon the respondent number 2 and 3 is have to be completed. LCR has also been called for.
Office note dated
17/7. First flag.
LCR has not been received neither ID card nor unserved notice for 2 and 3. You have appeared for whom?
For one.
2 and 3 who's for 2 and 3? Who is for 2 and 3?
Service is yet to be completed.
No, they have not appeared. And who are 2 and 3?
They are the builder and the owner of the.
Step taken?
Yes, sir.
When did you take step?
Immediately made to the order 28.
Notice issued on 13/7. Okay, we have some time. The HKNR?
Yes.
Learned counsel for the petition by referring to the office notes dated 13/7/2023 and 17/7/2023 has submitted that notices upon respondent numbers 2 and 3 were issued only on 13/7/2023 and neither ID card nor unserved notice has been received back. the LCR, was it called for?
Yes, scan copy of
LCR.
LCR.
Scan copy.
Scan.
The scan copies of the LCR has also not been received by this court. Your locker, what is your name?
M doctor.
M. Doctor. The M. Doctor has entered appearance for the response number 1. Please, after 4 weeks, along with press, to enable the office to make fresh report on service as well as for receipt of the scan copy of the LCR. Is there any interim order?
Yes, my lord. 28/6. There is an
Interim order, then we'll fix the date. Please not get 4 weeks. We'll have it on. We'll have it on 16th of August.
My lord.
16th of August.
Can we have it on some other day, my lord?
Prior to
Prior to 16, my lord,
14th of August.
14.
On 14th of August. Interim order passed by date. Then extended till the next date.
Apply.
Hearing, hearing, part 2, matter both for me. Part 4 for me. Part 2, we have a matter of 2002. Who is that? Mr. Ghosh, R. Chaudhary, J. Abidin, H. A. Sarkar. Please inform the council. We'll have the representative will have the first matter of today's part 1 hearing. But we'll give preference to the 2002 matter. There are 2002 matters, 8 matters. We'll complete those. Yeah. Yes, what is this? Arrest it. Recognize, huh? Recognize. Okay. Civil judge. Civil judge. Ordered. Civil judge. Alright. Yes, council. Don't think so. none had appeared for the parties when the matter was called up. This RSC is of the year 2006, pertaining to a suit of the year 1999. Sarah, it appears that pursuant to an order dated 6/2/2020 passed by this court, additional evidence. No, further evidence was also recorded, which has been transmitted in the LCR. Considering the above, the the hearing of the matter is referred for taking the second half. And how Nazmul Haq is there, Deori, H.I. Chaudhary. Kindly inform them if you know them. And Haq. Mr. Kulita. And Haq. Nazmul Haq. At 2 o'clock, not now, 2 o'clock. Yes, next.
With this appeals arising out of the same frequent has been made. But the one filed by us, Lord, is against reversal, and the other side has filed against confirmation on both sides. But my suit was for confirmation of possession, Lord.
There are two suits. One suit.
There was a counterclaim.
Okay, counter.
Only, Lord, may I indicate before that Mr. L. Gogoi appears on behalf of the respondent, Lord. In fact, both set of counsels have been newly engaged in this matter, Lord. That's his name. Has not been-
Bhagavati is not there.
No.
L. Gogoi.
L. Gogoi.
Lohit Gogoi.
Lohit. Leela Gogoi.
Huh?
Leela Gogoi.
Leela Gogoi. Name's not sure. Okay, we'll have this on Thursday.
Lord, I have one prayer, Lord. Lord,
Could you
Why?
inform Mr. Gogoi also?
I'll inform you.
Yes.
Lord, I had, Lord, applied for certified copies of some of the records, Lord, because that were not there in my record, Lord, which have been given to me,
You
Lord.
can inspect the court file, make your note,
Lord, yes, Lord, part I have done it, Lord. Only
make
because
your note. But photocopy we cannot put.
on certified copy, Lord.
Certified copy, it might take time. You make your note, no problem.
Okay.
We are to be Senate counsel for the appellant
And responding,
RSA 87 of 2009 submit that there is a change of counsel for the respondent, who is also the appellant, with the connection RSA 9 of 2010, whose name, however, has not been reflected in the counsel. Para, list this matter list these matters for hearing again on Thursday data by reflecting the name of the L. Gogoi as
and I'll personally inform him, Lord.
current counsel for the respondent, who is the appellant in RSA 9 of 2000 9 of 2010.
Fine.
You get it inspected by yourself
Yes.
or your colleague? Yes, Mr. Sharma, what is this?
Can it be summarized, Malad?
Why? 10 method.
10 method, Malad. Actually, one more thing, Malad. The respondent wife, Malad, the Binapani Talota, who was the earlier defendant in the suit, my lord. Her, my lord, the husband purchased a plot of land. So
You're
husband,
not for whom? Yes, you're for whom?
I'm for the plaintiff lordship, original plaintiff.
original plaintiff,
Your husband and wife or what? No.
No lordship.
he is alive, my lord, he is alive.
Initially, lordship, suit was filed by the present appellant plaintiff against lordship Binapani Talukdar.
Binapani has passed away.
Yes,
Passed
sir.
Now
Binapani
you're,
passed away, leaving
You're
behind
represented
two
by
legal,
Prakash Talukdar.
leaving behind two legal heirs, lordship. And those two legal heirs were subsequently substituted in the present appeal. My humble submission is that the rest of the legal heirs are said to be the sons and daughters of the previous wife of
One Bosanto
the
Talukdar.
wife of the husband of the present respondent, Binapani. Binapani, the present late Basant Talukdar married subsequently the present respondent Binapani also. Earlier he married one also. So those legal heirs are not necessary parties as because specifically the suit was filed against Binapani Talukdar seeking right category interest and recovery of possession. But in the counter claim, lordship, Binapani Talukdar said that no, my husband had purchased a plot of land measuring 1 bigha from me, lordship. So there arose some discrepancies for which she filed a counter claim under section 26 of the specific relief act, seeking direction for rectification of the sale is concerned. So my humble submission is that as because Binapani Talukdar in her written statement, as well as in the counterclaim, has not stated anything with respect to non-joint or necessary party. So under that circumstances, lordship, the legal heirs of the previous wife of the husband of the present respondent are not necessary party.
Are you raising this issue?
Not
No,
raised
my lord.
before the trial court.
No, trial court, this issue will not arise because that part has taken only picture independency of this appeal, isn't it?
Initially, the appeal suit was
While
filed
this
only.
appeal was
If lordship Binapani Talukdar is considered to be a legal heir of Basanta Talukdar lordship, under the circumstances, the other legal heirs of the
no, we have said that while this appeal was preferred, it was against Binapani Talukdar.
Yes,
She was
yes.
alive.
yes.
Now she passed away.
Ah.
She has passed away,
Yes.
isn't it? Now she has been represented by her children,
Children, lordship.
Prakash and another.
Yes.
And has any objection been raised that Basanta has another? They have got
No
different-
lordship, no lordship. There
Then
is
why
no
is the
pleading at
issue?
all, lordship.
So that
No
is not the
pleading,
issue.
lordship.
Why is that issue?
I am raising only, I am concerned that whole the plot of land, suit land is mutated in favor of all the legal heirs. That is why. Even if decree pass, there will be some discrepancies.
Now, Suitland has been mutated in the name
No,
of
no,
the
sir.
others also.
Yes.
Now, my Sutland was a different one. My Sutland was 2 bighas of land, lordship. In
Okay,
the
but
count,
we'll hear this. We'll hear this in this position. If something else arises, we'll pass the appropriate order. Yes, not today. Why?
Well, actually petitioner respondent wanted to engage some other, earlier Mr. Ardwara was there.
2010 matter, difficult. No, we'll not cause any difficulty to you, but we'll have it day after tomorrow. We'll not
Madam.
adjourn this. We can accommodate for a day, that's not a problem.
Well,
if possible, on 27, lord.
27,
27, lord.
10. That will not be a problem. 25th.
25th.
It's a Tuesday.
Lordship,
Or day
I
after
have-
tomorrow.
Lordship, I have some another
Day
matter.
after tomorrow.
Day after tomorrow, lordship, my paternal uncle died, lordship.
Okay, then Friday? Try on Friday. Friday is okay for you?
Yes, please. On Monday, lordship.
Okay, we'll have it Monday.
Monday.
2010 matter.
Yes, Monday.
Do this matter is of the year 2010, a short accommodation has been sought for by Sri N.K. Kulkarni. A learned counsel for the respondent. Sarah? Considering the above, the matter is directed for hearing again, hearing on 24th of 24th of. LCRs have. Kindly inform part 2 matters will take up 2002 matters. R Ghosh, JK, SK Ghosh, R Chaudhary, SK Ghosh, HK Sarkar. Yeah, bill.
Lordship, the matter may be on 26, Lordship, 20. Tuesday.
26 is not 26, 25th is Tuesday.
24th.
Tell us one day will not make any
On the
difference.
matter is fixed on 24th.
24th.
Yes, sir.
24th, Monday.
Yes.
Inform them, item number 1 of the state for the state effect. J. Abedin, R. Ghosh, SK Ghosh, HK Sarkar. On the other side, Parajuli, PK Roy. We'll take it up. Non-appears will dismiss.
My lord, Mr. S.K. Devi, he is appearing, my lord. He's out of discussion, my lord. He's not in today, my lord.
6th matter,
Lordship.
2006.
Yes, Lordship. But I'm trying to contact him, but I'm trying to contact him.
You're not returning this matter. Day after tomorrow.
Lordship.
If you don't appear, we'll pass orders.
Yes. Ask them. I will inform my.
A prayer for adjournment has been made on behalf of the appellate. Considering that this appeal is of the year 2006, the prayer is rejected. However, in the interest of justice, a short accommodation is granted directing listing of this matter again on 2/0.
Obvious.
In this case, Lordship, we are defendants, Lord. And both the court decided in favor of the plaintiffs, Lordship. Suit was for right title interest and confirmation of possession.
Who is on the other side?
PK Roy.
They will
the-
inform it.
Yes, Lordship, I have informed. They have some matter fixed at 2 before court, 2 or 3, Lordship.
Doesn't matter. This is the matter of 2002.
Yes. Plaint is at page 77. Lord.
You are the defendant.
Yes, Lord.
Page
77.
Yes.
Page 79 onwards, the statements, Lordship. First paragraph, this is a suit for declaration of title and confirmation of possession together with reliefs in respect of the land described more particularly in the schedule of the plaint. Your Lordship got that second arrest patta number 21 of Organa Rupaibali Mauja Rupaibali consists of dag number 634 with an area of land measuring 2 bighas 16 katas 13 chatak. The second arrest patta number 21 has been surveyed out of arrest patta number 137, which consists of one dag, that is dag number 527, with an area of land measuring 2 bighas 16 kata 13 chatak, and classification of the land is homestead land. The RS Patta number 137 has been surveyed out from CS Patta number 97 as well as CS Patta number 96. CS Patta number 97 consists of DAG number 687, 688, 689, 707, 788, 715, 716. There are altogether 7 DAGs with an area of land measuring 6 bighas. 15 kata CS Patta number 96 consists of DAG number 681, 682, 685, 686, 713, 714, 717. That while resurveying during the settlement operation, RS Patta number 137 was carved out by taking DAG number 686 from CS Patta number 96 with an area of 2 bigha, 1 katha, 2 chataks, and land belonging to CS Patta number 97, DAG number 687, 1K.3 chatak, 688. Also, these are the measurements. Total 2 bigha, 16 katha, 13 chatak. That is now RS Patta number 137 was surveyed out from CS Patta number 96 and 97, consisting an area of land measuring 2 bigha, 16 katha, 13 chataks. That CS Patta number 97 was issued in favor of Idris Mia, son of Sabu Mia, and Musammad Hauni Bibi, wife of late Talen Mia. That Sabu Mia and Gabru Mia were 2 brothers. Sabu Mia died leaving behind 4 sons, 1 daughter. They are Idris Mia, Kasim Ali, Abdul Rahman, Abdul Rahim, and Meherjan Bibi. Amongst the brothers, Kasim Ali died leaving behind 2 sons. They were 1 Abdul Aziz, Abdul Hai. Both Abdul Aziz and Abdul Hai died leaving the plaintiffs. Idris Mia
You
died
for all the defendants,
defendants, Lordship.
all the defendants.
Pro forma, I am not
No,
defendant.
main principal.
Principal defendant. Idris Mia died leaving only 2 daughters, Lordship, Adia Bibi and Laila Haji. Plaintiffs purchased their share by registered sale deed. That Gabru Mia died leaving behind 3 sons, Sikandar Ali, Bakatet Jaman, Kamrud Jaman, and daughter Musammad Taru Bibi. All of them died leaving their respective heirs, and they have been implicated in the suit. Principal defendants are the sons and daughters of late Kamrud Jaman. That Idris Mia, Abdul Karim, Abdul Rahman, and Kashim Ali by a registered deed of
You
reconveyance.
can come to the first court judgment. So facts of both the parties would be there.
Lordship. Only I want to show that there is a specific pleading by the plaintiffs that at the time of mutation, Lordship, it was within their knowledge that mutation was done, Lordship. For that part only, Lordship. Page 82, the
No, we have seen the prayer in the, that is a consequential relief.
no, Lordship. The mutation, my substantial question is that, Lordship, whether suit is barred by law of limitation. So for that, Lordship, it is required to show that the recording of name of the defendants in the revenue record, it was within the knowledge of the plaintiffs at the time of recording, Lordship, and it was recorded in the year 1913, Lordship. For that, only paragraph 6, your Lordship, I will read. There are 2 substantial questions of law, Lordship. One is on the point of law of limitation, and one is, Lordship, regarding fraud, Lordship, order 6, rule 4. Okay. Substantial question of law, your Lordship.
Yes, yes.
Lordship, only para 6 I will read out. Page 81, para 6, Lordship. May I read?
Page,
Page 81, para 6, Lord.
yes, please.
That Idris Mia, Abdul Karim, Abdul Rahman, and Kashim Ali, by a registered deed of reconveyance, got the land returned from one Badaruddin, son of Hilaluddin, including the land of CS Patta number 97 of Dag number 688. That the defendant's predecessor in interest, Sikandar Ali, Bakhter Jaman, Kamrud Jaman, son of Gabru Mia, collusively got their names mutated. This part will be required for deciding the substantial question of law number 2, Lordship. Collusively got their names mutated in CS Patta number 97, Dag number so-and-so, allegedly by right of purchase in the year 1912 and 1913, Lordship. Only word collusively, there is no explanation, Lordship, how the collusiveness was done by the defendants, Lordship. That objections were raised promptly against the false mutation for which it was cancelled. So, Lordship, they raised objections promptly. That means in the year 1912, 1913, Lordship. Against the false mutation for which it was cancelled, which is evident from the fact that their names did not appear in RS Patta number 137, save and except the name of Sikandar Ali, died leaving behind his daughter Musammat Meherjan Bibi, who was married to Usman Ali of Singarban. She died leaving heirs who are impleaded as defendant number 6A and 6B. But from the revenue records, it appears that instead of mutation of the name of Musammat Meherjan Bibi, wife of Usman Ali, the names of the brothers of late Sikandar Ali were again mutated. Lordship, as per Mohammedan law, if there is only a daughter legal heir, Lordship, the residuary part will go to the brothers, Lordship. So after deducting her share, Lordship, it is not correct that they have stated that without including the name of Meherjan Bibi, the brothers' names were mutated. It was the brothers' names were mutated only because that, Lordship, they have right over the property of Sikandar Ali, Lordship. As because he has no son, Lordship. He has only one daughter, Meherjan Bibi. So the residuary part they will enjoy, Lordship. For that, their names were mutated. And from this paragraph, it is admitted that the plaintiffs themselves admitted that in the year 1912-13, they objected to the mutation. That means it was within their knowledge, Lordship. But they have taken the benefit that in the year 1996, they came to know about the mutation. So they filed the suit in the year 1996. And that was the, Lordship, recording and the findings of the First Appellate Court also. So may I read the First Appellate Court judgment, Lordship?
First, let us read the
Trial court
trial court judgment.
Lordship. That is in page 27. Lord. May I read the factual part? Lord?
This is 29th of April.
Yes, Lord.
29th for 2000.
29th of April 2000. Lord. May I read the factual part or I'll read the issues, Lordship?
Page 27.
26, 27, Lordship.
Yes.
May I read the issues onwards, Lordship?
Yes.
Issues, Lordship, page 38. Bottom part, Lordship. Is there any cause of action for the suit? Is the suit barred by limitation? That is one of the substantive
Let see.
Lordship.
Let us read from 27.
This is a suit for declaration of plaintiff's right title interest over the suit land described in schedule of the plain with confirmation of their possession over the same on cancellation of the mutation of principal defendants in the record of rights, and also for granting permanent injunction restraining the principal defendants from encroaching upon the suit land and disturbing the peaceful possession of the plaintiffs, etc. The fact of the plaintiff's case appears in the plaint is that the principal defendants being the legal heirs and successors of Kamrud Jaman, son of Gabru Mia, having no right title interest over the land described in Schedule 2 of the plaint, taking advantage of their homestead on the land of Dag number 650, contiguous to the suit patta land, and also taking advantage of having false and collusive mutation of their names as well as their predecessors' names, threatened to dispossess the plaintiffs out of the possession over the suit land described in Schedule 2 on 5/6/95, 8/10/95, and 31/3/96, taking their claim over the same, which the plaintiffs have been possessing since the lifetime of their predecessor Abdul Aziz and Abdul Hai, Lordship, son of late Kashim Ali, who got their right by way of inheritance and also by purchase. On the death of Abdul Aziz and Abdul Hai, the plaintiffs being their legal heirs and successors inherited their interest over the land described in Schedule A inclusive of Schedule B and had been possessing the same by making regular payment of the land revenue. The plaintiffs have their homestead over the land described in Schedule 1 of the plaint where they have been living with their families since the days of their predecessor without any obstruction and objection from any quarter. The plaintiffs explained that the land described in Schedule 1 and 2, measuring 2 bighas, 16 kathas, 13 chatak, contained in Dag number 634 of second RS Patta number 215 was surveyed out from RS Patta number 137 bearing Dag number 527, which was also surveyed from original CS Dag number C8686 of Patta number 96 and Dag number 687, 688 and 689 of CS number 97. The original CS Patta number 96 was recorded in the name of Idris Mia, Abdul Rahim, Abdul Rahman, and Kashim Ali, son of late Sabu Mia, for an area of land measuring 17 bighas, 10 kathas, 14 chataks, consisting of Dag number 681 and so Dag, of which they got 10 bighas, 9 kathas, 10 chataks of land by way of reconveyance from Badaruddin Chaudhuri under a registered deed. Whereas CS Patta number 97 was recorded in the name of Idris Mia, son of Sabu Mia and Hawai Bibi, wife of Tolen Mia, in respect of 6 bighas, 1 katha, 15 chatak of land containing Dag number 687, 688, 689, 707, 708, 715, and 716. Idris Mia and Hauni Bibi did not dispossess any of their property to any person during their lifetime, but unfortunately Sikandar Ali, Baketad Jaman, Kamrud Jaman, having no interest over the property of CS Patta number 97, got their names mutated in the record of rights in respect of entire land of Dag number 688 illegally and collusively in the year 1913 with the help of revenue staff showing the same purchase. On getting information about the said illegal and collusive mutation, objection was raised, upon which mutation in the names of Baketad Jaman and Kamrud Jaman were cancelled during Operation Resettlement. Only the name of Sikandar Ali remained in the RS Patta number 137 due to omission of the staff as well as collusive influence of Sikandar Ali. In course of operation of first resettlement, the land under Dag number so were amalgamated into a single Dag and converted the same in Dag number 527 of RS Patta number 137, bearing total area of land measuring 2 bighas, 16 kathas, 13 chataks, and Patta was issued in the name of Idris Mia, son of Sabu Mia, Salima Bibi, wife of Abdul Rahim, Sirajun Nesa, Hayatun Nesa, daughters of Abdul Rahim, Abdul Rahman, son of late Sabu Mia, Kasim Ali, son of late Sabu Mia, and Sikandar Ali, son of late Gabru Mia. In the said Patta, the name of Abdul Rahim was not deleted out of mistake, although he died leaving behind his wife, Salim Bibi, and 2 daughters, namely Sirajun Nesa, and Hayatul Nessa, whose names have already been recorded in the arrest patta number 137. In the meantime, Sikandar Ali died, leaving behind his only daughter Meherbanu Bibi, who also died, leaving Ataur Rahman and Chobi Bibi as her heirs. But on the death of Sikandar Ali, instead of recording the name of his daughter Meherbanu, and after the death of Meherbanu, her heirs Ataur Rahman and Chobi Bibi, the names of Baktet Jaman and Kamrud Jaman were again collusively recorded in the patta. By that time, Pattadar Kashim Ali, son of late Sabu Mia, died, leaving two sons, Abdul Aziz and Abdul Hai, predecessor of the plaintiffs, but their names were not recorded in the suit patta, and in place of recording their names in the patta, the names of Baketul Jaman and Kamrud Jaman along with Sikandar Ali wrongly and fraudulently recorded as heirs of Kasem Ali, Abdul Aziz and Abdul Hai, while possessing the heirs of Kasim Ali. In the arrest patta number 137 died, leaving the plaintiffs as their heirs and successors who continued possession of the same. The predecessor of the plaintiffs, Abdul Aziz and Abdul Hai, also purchased the share of Idris Mia from his daughter Laila Bibi and Asia Bibi, who succeeded the entire share of Idris Mia on his death. Thus, predecessors of the plaintiffs became the owners of the share left by Kasim Ali and half of the share of Idris Mia in the arrest patta number 137, and on their death, the plaintiff succeeded the same and continues to possess over the said property, where they have their residential house and they have been residing there with their family. Pattadar Abdul Rahman died, leaving two sons, namely Abdul Jabbaruddin and Meheruddin, and one daughter, Samsun Nehar. Meheruddin died, leaving his only daughter, Hasar Banu. Their names have already been recorded in the patta. During the operation of second resettlement arrest patta number 137, containing DAG number 527, converted into second arrest patta number 215, containing DAG number 634. It is also alleged that the name of one Abdullah Mia, son of Asan Mia, have been illegally recorded in the Jamabandi, showing auction purchaser of 4 katha, 11 chataks, 10 gondas of land. Fictitiously, though there was no such person named after Abdullah Mia in the locality. According to the plaintiffs, due to the staking claim of the principal defendant on the land described in Schedule 2 and threatening the plaintiffs to dispossess from the possession of the same, clouded the right title interest of the plaintiffs. Hence, the plaintiffs filed this suit seeking declaration of their right title interest over the schedule mentioned land with confirmation of their possession thereon, and also for granting permanent injunction against the principal defendants. The pro forma defendants number 5A to 5D, 6A to 6B, 6A and 6B, 10A, 11A to 11D, 12A and 13 to 19 have not contested the suit. Hence, the suit proceeded ex parte against them. The suit against pro forma defendant number 8 and 9 were dismissed on abatement, and against pro forma defendant number 7 is also dropped. The defendant 1 to 4 appeared in response to service of summons and contested the suit by presenting written statement containing the grounds inter alia that the suit is not maintainable in its present form, as there is no cause of action for the suit and the same is barred by law of limitation, as well as hit by the principle of estoppel, waiver and acquiescence. Besides, the same is barred under the provisions of Assam Land and Revenue Regulation Act and under the Specific Relief Act. Further, the suit is bad for non-joinder and misjoinder of necessary parties, and the suit has not been properly valued and stamped. The defendant denied the fact of Idris Mia, Abdul Rahim, Abdul Rahman, and Kasim Ali ever got reconveyance of any land in the suit patta from Badaruddin, and also denied the factum of predecessor of plaintiffs purchased the share of Idris Mia from his daughters Asia Banu and Laila Bibi. The defendants further denied the allegation of Sikandar Ali, Bakatur-Zaman, and Kamruz-Zaman got their names recorded in the suit patta fraudulently and collusively, and they ever threatened the plaintiffs to dispossess from the possession of the land described in the schedule of the plaint. The defendants admitted the fact of land under second arrest patta number 215 containing dag number 634 measuring an area of 2 bigha, 16 katha 13 chataks have been surveyed out from the land under under arrest patta number 137 containing dag number 527, which was also carved out from the land covered by dag number 686 of CS patta number 96 and dag number 687, 688 and 689 of CS number 97. They pleaded that CS patta number 97 stands in the name of Idris Mia, son of Sabu Mia, and Hanwi Bibi, wife of Talen Mia, each having equal shares over the entire patta land, who subsequently sold out their entire share of land covering dag number 688 measuring 5 katha 7 chataks in favor of Sikandar Ali and his two brothers Bakatur-Zaman and Kamruz-Zaman, predecessors of defendants, and delivered possession thereof. Since the date of such sale, Bakatur-Zaman, Kamruz-Zaman and Sikandar Ali were in continuous possession of the same and also got their names mutated in the record of rights. Thus, they became the owner of said land. They also pleaded that the land pertaining to other dags of patta number CS 97 belonging to the share of Hauni Bibi all along remained under occupation of Sikandar Ali, Bakatur-Zaman and Kamruz-Zaman, as Hauni Bibi never possessed the said land despite having her names recorded in the patta, and the possession of Sikandar Ali, Bakatur-Zaman, Kamruz-Zaman are peaceful, exclusive, continuous, uninterrupted, open and hostile to all in respect of the share of Hauni Bibi more than the prescribed period of 12 years. In this way, they acquired valued right, title, interest over the land belonging to the share of Hauni Bibi, excepting the land under dag number 688. Thus, the predecessor of contesting defendants, late Kamruz-Zaman, and his two brothers, Bakatur-Zaman and Sikandar Ali, became the absolute owner of entire dag land of dag number 688, measuring 5 katha 7 chataks of CS patta number 97, and also half of the share of dag number 687 and 689 of CS patta number 97 by right of possession, and they had possessed the same till their death. So our claim is, Lordship, by right of possession and by right of purchase in two dags, Lordship. It is also pleaded that Idris Mia died leaving behind his two daughters, namely Asia Bibi and Laila Bibi, along with his brother Abdur Rahman and sister Meherjan Bibi as their legal heirs and successors to his half share of land containing dag number 687, 689 of CS patta number 97. So his two daughters, Asia Bibi and Laila Bibi, inherited 2/3 share over the half share of interest belonging to Idris Mia over land under CS dag number 687, 687, and his brother Abdur Rahman and sister Meherjan Bibi inherited their right over the share of Idris Mia at the proportionate rate of 3/9 and 1/9 share of interest respectively. And as per the principles of Mohammedan law, as such, the two daughters of Idris Mia, Asia Bibi and Laila Bibi had no right to sell entire share of interest belonging to Idris Mia, and therefore the plaintiffs did not acquire any valid right title interest over the share of Idris Mia in the patta land of CS 97. It is further stated by the defendants that Sikandar Ali died leaving behind his daughter Meherban Bibi along with his two brothers Bakatur-Zaman and Kamruz-Zaman and one sister Tanu Bibi as his legal heirs and successors to inherit the share of his land covering dag number 687 and 689 of CS patta number 97. Then Kamruzzaman died, leaving behind the principal defendants to succeed his own share over the land under Dag number 687, 688, and 689 of CS number 97, which he got by way of purchase as well as inherited from Sikandar Ali. Baqatuzzaman gifted out his share of land got by way of purchase and also by way of inherited from Sikandar Ali in favor of defendants prior to leaving this mortal world, and delivered possession of the same, which had duly been accepted by defendant number 2 on behalf of all. By this way, the principal defendants and the legal heirs of Meher Banu Bibi and Tanu Bibi became the owners of land measuring 5 katha 7 chatak, appertaining to Dag number 688 of CS Patta number 97, in addition to half of the remaining land 2 bighas 11 kathas 6 chataks contained in Dag number 687 and 688 of CS number 97, that is 1 bigha 5 katha 11 chataks, which raised the total share belonging to them to 1 bigha 11 kathas 2 chataks, subsequently converted to Dag number 634 of second RS Patta number 215, and they have been possessing the same continuously since the lifetime of their predecessor. According to the contesting defendants, the suit patta land had never been partitioned among the co-sharers, and the plaintiffs all along remain out of the possession of land described in Schedule 2. Therefore, the plaintiffs have no right, title, interest, and possession over the same, and as such, they are not entitled to get the relief sought for, and the suit is liable to be dismissed with cost. Having perusal of the pleadings of the respective parties and hearing them on the same, following issues were settled for just determination and decision of the suit. First Lordship, is there any cause of action for the suit? Is the suit barred by limitation? Is the suit bad for defect of necessary parties? Is the suit properly valued?
Here, I think issue number two.
Two, Lordship. Two
Issue
is,
2 and issue 5, I think.
yes, Lordship.
5.
Yes, Lordship. These are the only two substantial questions of law. So may I read issue number 2, Lordship?
I think that is okay.
Page 57.
Yes.
The defendants in para 3 of their written statement allege that the suit is barred by law of limitation. The learned counsel for the defendant in support of the above averments contended that in the instant suit, the prime object of the plaintiff is to get cancellation of the mutation of the predecessor in interest of defendant, namely Sikandar Ali, Baqatuzzaman, and Kamruzzaman, which was recorded in the year of 1913, that is more than 80 years back. The limitation for such cancellation is 3 years from the date of right to sue. He contended that the defendants Abdul Hakim, Abdul Mannan, Abdul Hannan, and Ibetun Bibi also got their names recorded in the suit patta about 17 years back, and the plaintiffs did not raise any objection against the said mutation within the said period and remain asleep till the year 1996. So according to the learned counsel, the suit is absolutely barred by law of limitation. The learned advocate referred the evidence of PW1 recorded in page number 17 and 18, where he admitted that the mutation of the predecessors was done more than 50 years back. But the case seeking cancellation of mutation has been filed, causing more than 50 years delay. In reply to the point of barred by limitation, the learned counsel for the plaintiffs submitted that the suit is not barred by law of limitation. The learned counsel for the plaintiff argued, though the mutation of Sikandar Ali, Baqatuzzaman, and Kamruzzaman was recorded in the record of rights in the year 1913, and then Baqatuzzaman and Kamruzzaman again in the year 1919. But they never stake their claim over the possession of the schedule mentioned land, and plaintiffs remain all along in continuous possession over the suit land. He contended that the plaintiffs were not aware of the fact of defendants and their predecessors in interest illegally or collusively got their names recorded in the suit patta in respect of the land described in Schedule B. They only came to learn about such illegality in the year 1994. So, Lordship, they tried to convince the court that from their date of knowledge, they came to know that the lands were recorded in the name of the answering defendant. But in fact, Lordship, in the plaint itself, they admitted that then and then they objected. Lordship. So in the year 1913, 1912 and 13, they objected. They only came to learn about such illegality in the year 1994, while the principal defendants take their claim over the Schedule B land in the guise of false and collusive mutation of the predecessor in interest in the year 1994, and threatened the plaintiffs to dispossess from the Schedule B described land. The learned advocate for the plaintiff explained that on the speaking claim over the Schedule B described land by the principal defendants, the plaintiffs made inquiry into the claim of the defendants and ascertained the fact of collusive mutation of the predecessor in interest of the defendants on, Lordship, these are the dates, on finally on 3/5/96 by obtaining certified copies of relevant documents. Upon perusal of the certified copies of Jamabandis of second arrest patta number 215, arrest patta number 137, CS patta number 96 and 97 marked as exhibit 1 to 4, as well as certified copies of mutation order dated so and so marked as exhibit 12, it can be presumed that the plaintiffs finally came to learn about the collusive, false and illegal mutation was done in respect of recording the names of the predecessor in interest of the defendants, and thereafter the names of the defendants in the record of right of the suit land only on 3/5/96. After obtaining the certified copies of the mutation application and the order. As per Article 59 of Limitation Act, the period for 3 years to cancel or set aside an instrument or decree started from the date of knowledge about the fact of instrument or decree sought to be cancelled. It is revealed from the certified copy of order dated 29/8/13, marked Exhibit 12, as well as from the evidence on record that the plaintiffs came to know about the false and collusive mutation of the names of Sikandar Ali, Bakirjaman and Kamruzzaman, and then the mutation in the names of defendants first only in the year of 1994 and 1995, while the defendants threatened them to dispossess out of the possession of the suit land, and they filed the suit on 8/5/96, that is within 3 years of their knowledge about the illegal mutation. So this is the perverse finding, Lordship. PW1 already admitted.
Who is PW1?
PW. Abdul Rashid Chaudhary, he is the son of Abdul Hakim, maybe. Son of late Maulavi Abdul Aziz Chaudhary. I'm just reading, Lordship, one portion. Gabru Miar Chelegone 1912-1913 ইংরাজি সনে যুগাযুগিতে means অবৈধভাবে সিএস পাট্টা নাম্বার 97 পাট্টার 688 দাগে খরিদার সূত্রে বাইট মিউটেশন কেস নাম্বার সয়েন্সর হুকুম মতে নামজারি করাইয়া নেন। পরে সরজমিনে আপত্তি দেওয়ায় সেকান্দার আলী ব্যতীত অন্য কাহারো নাম রিজরিপা কালে ওই পাট্টাতে ভুক্ত হয় নাই। সেকান্দার আলী তাহার একমাত্র মেয়ে মেহেরবানকে উত্তরাধিকারী রাখিয়া মারা যান। মেহেরবান বিবির সিঙ্গেরবন নিবাসী উসমান আলীর সাথে বিবাহ হয়। সাউবি বিবি আর আতাউর রহমানকে উত্তরাধিকারী রাখিয়া মেহেরজান বিবি মারা যান। তাহার 6A and 6B নাম্বার বিবাদী, তাহার লিগেল হেয়ার। সেকান্দার আলী মারা যাওয়ার পর তাহার মেয়ে মেহেরবানের নামে নামজারি না করিয়া সেকান্দার আলীর ভ্রাতা কমরুজ্জামান ও বক্তজামানের নাম সেকান্দার আলীর স্থলে পাট্টায় নামজারি করাইয়া নেন।
In fact, I'm sorry, but I was stuck up. But in fact, To be honest, my lord, I was not so much, I've not gone through so much, my lord.
No, 2002 matter.
That's right, your lordship is right. my lord. But since,
We have to make a start at least.
that's right. Yeah, concurrent.
So unless we make a start, we'll
No,
not.
no,
finish.
let my learned friend complete,
No, no, we have just started. The
And they-
concurrent finding,
My lord,
concurrent finding.
concurrent, concurrent.
He
Concurrent,
is raising 2 points. One is the point of limitation.
my lord, limitation.
Yes, and the other is,
My lord, it's a mixed question of law and fact, cannot be gone into second and appeal. That is the provision of law, there is Supreme Court judgment also.
no, there is law, the question, as you rightly said, the mixed question of law as well as fact. And
So
substantial questions of law is a question of law which is substantial to the case in hand.
that's
Doesn't mean a very big question of law. It has to be substantial to the facts in hand.
facts. Sir. So if it is facts, then my lord, in second appeal, or other lordship, because or High Court
No,
will
it
also.
can be substantial question pertaining to fact.
If it is
if the
perverse, there is a perversity, not of course.
And the other is a collusion and involvement of Order 6 Rule 4.
Collusion is not gone into by the appellate court, because the collusion was not pleaded there. The appellate court collusion suddenly cannot come, and there is. I mean, the lordship leads the, the plaint also, lordship will find adequate.
Now, she's trying to make it a point that you knew about the fact so far as dilating on the issue of limitation.
But
You
then,
have made a statement that 2013-14, then itself you had come to know, but you had raised this issue quite late.
no, when the court, finding of the court is, as soon as we came to know about it, we applied for a certificate copy, then only we
No, that
filed.
is the finding, but your admission in the plain, he
No,
was trying to stress upon that.
I don't think.
There is
Para 7 of the. plain
paragraph 7, paragraph 6 and 7 at page 81.
Lord.
I'll look into it, my lord.
And now, your lordship, in regard to order 6 rule 4 lordship,
Hmm.
issue number 5,
5, correct.
that is page 53, Lord. That was discussed earlier, then law of limitation was discussed, issue number 2 was discussed later on. Page 53, issue number 5, the plaintiffs in their plaint allege that the predecessor of principal defendants, Kamrud Jaman and his two brothers, namely Bakatat Jaman and Sikandar Ali, collusively got their names mutated in the record of right of CS Patta number 97 in respect of entire Dag land of Dag number 688, showing to have been purchased from Idris Mia and Hauni Bibi. According to learned advocate for the plaintiff, neither Idris Mia nor Hauni Bibi during their lifetime sold any land of Dag number 688 of CS Patta number 97 in favor of Sikandar Ali, Bakatat Jaman and Kamrud Jaman. His contention is supported by the defendant number 1, who disclosed in his cross-examination disclosed that there is no any documents in their possession showing the fact of land containing Dag number 688 of CS Patta number 97 sold by Hauni Bibi to Sikandar Ali, Kamrud Jaman and Bakatul Jaman. Exhibit 3 certified copy of CS Patta number 97 shows that Sikandar Ali, Bakatul Jaman and Kamrud Jaman got their names mutated on the strength of order dated 27/8/1913, passed in connection with mutation case number 1807, 1912 and 13, showing the entire land under Dag number 688 purchased from Idris Mia and Hauni Bibi. But the defendant number 1, while deposing as DW1, has stated that Sikandar Ali, Bakatul Jaman and Kamrud Jaman purchased the land under CS Dag number 688 from Hauni Bibi. The evidence of DW1 found contradictory to the contents of entry in CS number 97 as regards purchase of land under Dag number 688. Exhibit 12 certified copy of application filed by Sikandar Ali, Bakatul Jaman and Kamrud Jaman seeking mutation of their names in CS Patta number so and so in respect of land contained in Dag number 688 measuring 8 Katha 7 Chatak, claiming to have been purchased from Pattadar Idris Mia and Hauni Bibi. Report of Lot Mandal submitted in the said case shows that on field verification he found that the applicants have been possessing the land since 8 Jastha of 1316 Bangladesh. On being purchased under a registered deed from Idris Mia and Hauni Bibi. The report does not indicate the deed number. There is no indication about service of any notice to the pattadars and hearing them in the order of mutation. This clearly shows that mutation order passed behind the back of the knowledge of Pattadar Idris Mia and Hauni Bibi. The applications for mutation shown to have been filed on 27/6/13, where Lot Mondal submitted his report on 23/8/93, and a mutation order was passed on 29/8/13. This also that the applicant Sikandar Ali, Bakatul Kamruzzaman got their names mutated in
No,
respect
this is not clear. Application for mutation shows that they filed on
27/6/13.
well, Atmanda reported on 93,
93, Lordship.
I think this will be 13.
Lordship, we have to go by the exhibits, Lord.
Still 13.
13.
Mutation
Lordship.
order is of 29/8/13. I
13.
think it's 23, it should not be 93, it should be 39.
Yeah.
Mr. Roy,
My lord.
at page 55,
Okay. Yeah, Vijay. Which one, my lord?
shows the last 5 lines.
Oh.
The application for mutation, have you got?
Mutation to have been
So,
filed
have been filed on 27/6/13,
13.
where Latmandal submitted his report on 23/8. I think this is
That I
13.
think, my lord,
13.
this is, I think this is a mistake. My lord.
This
It
is
can't
13, I think. Should be 13.
be 13.
And the mutation order, because it's dated 29/8/13,
It can't be. my lord.
cannot be 90.
And then order is passed on 13. Lordship is right, my lord. It can't be.
But the initial, that was of which was 1912/13.
That is
Yes,
last question. My lord, what was that?
1913, Lordship. It is 1913.
No, that was,
It is
that
not
was,
1993,
my lord,
Lordship.
that was
Understood.
cancelled.
So it
Lordship.
should not be 93, it is 13.
Yes, Lordship. 12/13, in the year 12/13, Lordship.
No,
the
no,
mutation
here
was
in
done.
the second date,
Second
Latmandal,
is 23/8.
it should be 23/8/13.
Yes, Lord.
And the mutation order was passed on 29/8/13.
8/13.
We are not on.
So there is no
2000.
enabling.
No, but-
Yes, Lordship.
But that order was, the question doesn't arise now. That is cancelled long back. Thereafter only they made a fresh thing. That is cancelled in the as per pleading I find. That was,
This mutation was cancelled.
I think, my lord, this is
That
the-
I have stated, Lordship, in paragraph 7, they have stated that immediately they objected, then
No,
the
no,
mutation.
that was cancelled. Object my please, 12, 13, we cannot be there. my lord. That was cancelled under objection by somebody, but then that was cancelled. Thereafter they made, that was cancelled. After the cancellation, that question doesn't come. my lord.
Cancelled, but Lordship, the name of Sikandar Ali remained.
But then that mutation doesn't make the question of limitation, that mutation.
If that was
As per
cancelled,
as per their
then
claim, Lordship.
the question of knowledge will not come.
They will not come.
Actions were taken at that point of time on the objection of whoever objected.
Lordship.
That mutation was cancelled. So by saying that they had knowledge and they remained to be silent, that question perhaps will not come.
Lordship,
When
that
did you, when was the first again mutation came into being, when your names came into existence?
It is only after that we find.
Because the question of collision is also there.
no,
You
Lordship.
say after the cancellation again by collision
No, Lordship. Their paragraph 7 says
of the
plain, Lordship. May I read again, Lordship? That the defendant's predecessor in interest, Sikandar Ali, Bakatul Kamruzzaman, collusively got their names mutated in CS Patta number
you are at page
97
81.
82, Lordship. Para 7 of the plaint, Lord.
Page 82.
Page 82.
Right.
That the defendant's predecessor in interest, Sikandar Ali, Bakatul Kamruzzaman, collusively got their names mutated in CS Patta number 97, Dag number 688, allegedly by right of purchase in the year 1912 and 13. That objections were raised promptly against the false mutation for which it was cancelled, which is evident from the fact that their names did not appear in RS Patta number 137, save and accept the names of Sikandar Ali, means Sikandar Ali's name remain, Lordship. It was cancelled, but whether they have, Lordship, evidence was forwarded in regard to cancellation, Lordship.
No, have you?
It was only pleading, Lordship.
No, have you rebutted this? in
Yes,
the
Lordship.
WS?
In written statement, we have objected to all the.
Have you, what is your written statement so far as the pleading to 7 is concerned? Come to page 94, 17. Paragraph 7.
That the statements made in para 7 of the plaint are not true and correct. It is absolutely false to state that defendants, predecessor in interest Sikandar Ali so and so got their names mutated in patta numbers released by right of purchase in the year 1912-13. Collusively, that is denied, Lordship. And that objections were raised promptly against the false mutations and that for which it was cancelled. So we denied the allegations, Lordship.
For which?
And that which is evident from the fact that their names did not appear in so and so except Sikandar. It is not a fact that Sikandar Ali died leaving behind his daughter Musammad Meher Bibi. It is absolutely false to state that the names of the brothers of Leza were again mutated collusively and mostly by suppressing the truth. So there is a denial from the defendant, specific denial, Lordship.
No, they have also qualified their statement by stating that in the RS Patta of number 137,
Lordship.
except the name of Sikandar, the rest of the names did not appear.
That we denied, Lordship.
No,
For
that is
that
a
they
matter-
have
that
a
is a matter-
cancellation order. They
That is
have
a
to
matter of record.
Lordship.
You have exhibited RS Patta 137. Is that right? Or there has to be an statement on oath that in your affidavit or
Exhibit 1 and 2, RS Patta number 137, RS Patta number 215. Two Jamabandis were exhibited. Lordship.
so RS Patta 137 did not have your name except Sikandar.
That I have to go through.
So this is evidence. So what is your case then? You said that it was not.
We have purchased some portion, we have purchased and
No,
some.
no. So far as this statement is concerned,
Lordship.
that the action of yours in having your names inserted in the records of right that was objected to cancel. According to them, you have said it is denied.
Yes, we have
Now,
denied.
your name continued to be there in the records of right.
Yes, Lordship.
But RS Patta does not have your names except Sikandar. What is your experience?
Lordship. The real facts we have stated in page 98, Lordship.
In your WS?
Yes, Lordship.
Best would be to read the discussion of the issue number 5, I think, at page 53,
Lordship.
which we were just doing. Let us complete that, I think, then we can.
Lordship.
Yes. We were at page 55.
So, Lordship, page 53, issue number 5.
We are at page 55, I think.
Lordship.
It's at 8.
Yes,
Yes.
Lordship.
Hmm.
This also.
This report
This
does not
report,
indicate.
yes, Lordship. That the applicant Sikandar Ali, Bakal Jaman and Kamruz Jaman got their names mutated in respect of land under DAG number 688 collusively with the staff. The plaintiff stated that immediately after getting information
Where is
about
the
page 56, Lordship.
56? Oh, 56. Okay. That was
After
not-
those dates, Lordship, I read. Now page 56.
Yes, yes.
The plaintiff stated that
Right.
immediately after getting information about the fact of Bakirjaman, Kamruzzaman and Sikandar Ali, the Pattada raised objection against such mutation. The Pattada raised objection against such mutation for which the names of Bakirjaman and Kamruzzaman deleted from the Patta, while the CS Patta number 97 converted to RS Patta number 137. But the names of Sikandar Ali remained recorded due to omission and taking advantage of remaining the names of Sikandar Ali. Bakirjaman and Kamruzzaman again got their names mutated in the record of right, along with the daughter of Sikandar Ali, showing heirs of Sikandar Ali. Exhibit 2, certified copy of Jamabandi of RS Patta number 137. Supported the contention of the plaintiffs. Exhibit 2,
Bakiruzzaman and Kamaruzzaman are legal heirs of Sikandar.
no, Lordship, as per Mohammedan law, they will become legal heirs of Sikandar along with his daughter.
Daughter,
Lordship.
that is it. So is the meaning of this part is that by their case, not your case,
Lordship.
that in spite of the cancellation,
Lordship.
name of Sikandar remained, and after Sikandar taking advantage, Bakiruzzaman, Kamruzzaman and his daughter came into existence.
Lordship.
After
As
Sikandar had
per
died.
their claim, Lordship, it is a collusive action of the defendants, Lordship. But in fact, even if we assume for argument's sake, Lordship, their names were again recorded, that will be as per Mohammedan law, Lordship. They will also become the legal heir of Sikandar Ali, Lordship.
No, see, here,
Assuming, Lordship, for the
here two questions will come. Now, if you are denying
Lordship.
that names of initially they had said that they contain the names of Sikandar, Bakiruzzaman, and Kamaruzzaman,
Yes, Lordship.
and in there was a cancellation on their request or whatever application.
Lordship.
You are denying is a different matter. Will come to that.
Lord.
And in spite of the cancellation, somehow the name of Sikandar remained.
Lord.
And after death of Sikandar, his two brothers and daughters, if you say that by Muhammadan law they can come.
Lord.
But if you say that, you will be your stand will be wavering. And
That
if
I have
if you are
admitted
saying
that
that there was no cancellation,
Lord.
then the names of Bakiruzzaman and Kamaruzzaman will remain not because of their legal heirs of
Lord.
Sikandar.
Lord.
They were earlier also in the
Lord.
records of right. If you admit that they came into the picture only on the death of Sikandar, they being the brothers, and not the Muhammadan law, along with his full existing daughter, brothers will also get a share. Then your first part may get affected.
That part I am admitting. That means that part I am admitting.
That part,
Lordship, for that, I am only on the discussion of the courts, Lordship, how they discussed, and it
no,
should
but,
be-
but then in that case, I think though you should not bring in the concept of legal heirs.
Lordship.
You say maybe because of Sikandar, his daughter came, but Bakiruzzaman and Kamaruzzaman names were already there. It was never cancelled.
Lordship.
And only because of that of Sikandar, names of also daughter came in.
Maybe it was wrongly deleted their names, so they raised objection, and later on their names were also recorded, Lordship.
Maybe.
That may be, Lordship.
But,
Those documents.
but
we
what is the funding of the court? We have to go by that. And the
Lordship.
affirmation by the appellate court.
Lordship. Their case is that, Lordship, collusive acts of the defendant. They included their name again in the Jamabandi, Lordship, by collusively.
And tell us what is your source of right?
That by purchase and by Lordship from possession, we have already stated in the defendant's case, already I have read out in the judgment, Lordship.
Purchased from whom?
Two persons, Lordship,
registered-
Idris Ali and Hauni Bibi.
By registered till date.
Yes, Lordship. By registered
Exhibited.
No, those were not exhibited. Only exhibit A to these are the rent receipt, Lordship. Some of the rent receipt, the defendants.
Unless you
exhibited.
prove your source.
First, Lordship, plaintiff has to prove his case, Lordship. If plaintiff fails, then only defendant has, and I have no counter
What
claim.
is their evidence?
Their suit, when the defendants raise, then their suit is barred by limitation, Lordship. That is a pure question of law,
No.
Lord.
Plaintiff, while making the claim,
Lordship.
what was their source of right?
By inheritance, Lordship, that they,
Inheritance is gone.
no, Lordship, by right of purchase, but they have not submitted any sale deed, Lordship.
No.
Their
Exhibit
exhibit is 1 to 8. 8 is registered deed of reconveyance, registered deed number, Lordship. 7, 8, 9, the registered deeds they have exhibited. Whether those were proved or not, Lordship,
Exhibited deeds that they are exhibited.
Lordship.
See, ultimately, it's a question, if you, even if you, for a moment,
Lordship.
you forget the two questions, substantive questions of law,
Lordship.
you have to see what is their claim, the claim is based upon what source,
Lordship.
vis-a-vis your,
My claim, Lordship.
now you have said that there are 3 registered deeds
Lordship.
by which they claim that they have acquired the position or the title. And you also say that there are some documents, but you have not exhibited.
No.
In those, under those circumstances,
1912 and 13, Lordship, on the basis of purchase, they have recorded their names, Lordship. There is a Mondal reports also. It reflects in the Jamabandi also, Lordship, and that is admitted.
for 12, 13, that recording of right, that has been cancelled.
Lordship, that cancellation order was not exhibited, Lordship. Is there on
But what
merely
is the-
saying that
what
it
is the
was
finding- what is
cancelled,
the- What is
Lordship?
the finding of both the courts on the cancellation part? Has it been,
No,
has it been
there was
accepted
no
or denied?
discussion in regard to cancellation, Lordship. Merely saying that, Lordship, that the order was, mutation was cancelled, it will not justify, Lordship. They have to prove that cancellation order by exhibiting, but they have not exhibited that cancellation order, Lordship. While we denied that part, that our names were not cancelled, Lordship. It is the duty of the plaintiff to prove their case, Lordship. It is not the duty of the defendants to disprove their case, Lordship. Had it been a case that we have
No,
filed our
obviously,
counter claim, Lordship.
the onus will shift upon you after
Yes,
they
Lord.
discharge their.
Lordship. And main
burden.
question, Lordship, whether suit is barred by limitation. If this question, Lordship, I can prove this question, Lordship, their suit will go, Your Lordship. That is a purely question of law, Your Lordship.
Quick question.
Lordship, to 1912, 1913 mutation, they raises objection in the year, Lordship, 1996. Lordship.
No, this question of repetition will come only when you can, or we can come to a conclusion that there was no cancellation at that time of 13,
Lordship.
12, 13. First time they have.
They have to prove that there is cancellation. The cancellation order they have to prove.
And in
Then
spite of such cancellation, there was
Lordship.
again collusive
Recording of
your right, of your.
and mere Lordship, I am having some judgments, the Constitution bench judgment, merely saying the collusiveness on the part of defendants,
Those have to be proved.
Lordship.
Collusion cannot be just alleged. It needs to be proved.
Lordship. How collusiveness was done by the defendants, they have to prove, Lordship, whether the revenue staffs were called, that saying that yes, it was done collusively in the year 1912 or 1913. That part is to be proved, Your Lordship. Merely saying that, Lordship, collusion, that order 6 rule 4
Yes,
says, Lordship,
suppose
it should be specific.
For a moment, let us also forget the collusive.
Lordship.
Even by inadvertent mistake, if our names are wrongly recorded, then that part should not be decided. But still, the question of limitation may be there. Which you are
Lordship.
raising. See, giving all benefits to you, there is no collusiveness. Somehow, your names were recorded, maybe by inadvertent mistake. There was no collusion. You did not have any. But that will not preclude them from filing an application for correction.
Lordship.
Collusion is not a precondition for going for a correction. May not be collusion. It can be an inadvertent error, a bona fide mistake. Somebody's name has come in some part. But you may be correct in contending that whether it was pointed out within the prescribed period of limitation.
Lordship, in fact, Lordship, they have exhibited Exhibit 12 certified copy of application filed by the defendant seeking mutation, Lordship. But they have not exhibited the cancellation order.
When was this application dated?
Application was, Exhibit 12 was there, Lordship.
The date?
Date I have not written, Lordship, only.
No. Exhibit that will be
Exhibit 12, Lordship.
There will be a
That
date.
is dated to 1912, 1913. Mutation case was initiated on the basis of our application. That application was exhibited, Lordship. But they have not exhibited the cancellation order.
No, your exhibit 12 is your exhibit,
No, Lordship, plaintiff's exhibit.
but your document.
Yes,
This
Lordship.
claim to be that it's your
Yes,
document.
our application.
It was on the basis of what? So what was the source?
By right of purchase, Lordship, as because the mutation order itself says that by right of purchase, we are claiming our recording of
Where
names.
is the mutation order?
Exhibit 12, your Lordship will find that is a certified copy of application filed seeking mutation.
Where is the mutation order?
Mutation order, they have not exhibited. Lordship.
No, no, it has to be.
Exhibit 1 and 2 are the certified copies of Jamabandi.
Let us see the Jamabandi. Let us see the Jamabandi. The
Lordship,
order will be
Exhibit
reflected.
3 is the certified copy of CS Patta number, Lordship 97.
No, no, come to the Jamabandi.
Yes, sir.
No.
Lordship, may I go through the
In the Jamabandi, the order will be reflected. The
Lordship?
source. Sir, where are your deeds or deeds of conveyance by which you had acquired the title? Which exhibit?
Oh, my lord, I find exhibit 8 is a sale deed, I find. My lord, I have put a note. I think 7, 8, 9.
Exhibit 8. In the judgment, where is it part of the judgment? From where you have acquired the right title?
11.
Trial court judgment.
Yes, yes, we have got. Come to page 42.
42, my lord.
42.
Yes.
Last line, last line.
Last line.
Plaintiff,
In support of their claim,
plaintiff, last plaintiff, Abdul Rashid.
Abdul Rashid.
Last line.
Abdul Rashid,
While
deposed, PW1 disclosed that in 1909 his grandfather Kashim Ali and his three brothers Idris Mia, Abdul Rahman jointly purchased the land contained dock number 687, 688, 689, 707, 708, 715 and 716 in CS Patta 797 from his Badruddin Chaudhary under a registered sale deed of conveyance marked as Exhibit 8. Yes. Besides having their half interest over the said Patta land, which they got by right of inheritance from their predecessor Subbu Mia. Exhibit 8 registered 549. Besides Idris Mia, Abdul Rahim, Abdul Rahman, and Kashim Ali purchased 3 bighas, 1 kata, 6 chatas of land containing dag number so entered land and the said dag CS 97 from Badruddin along with other land of Patta number CS 96 33 127 on 8709. But but exhibit 3 shows CS Patta number 97 recorded in the name Idris Mia Hawaii Bibi. During Operation CS, the names of Kashim Ali, Abdul Rahman, Abdul Rahim were not recorded in Patta number 97, although they have acquired their right over the land under CS Patta number 97 by right of purchase under deed number 549 marked in Exhibit 8, which is 30 years old document. The grandfather of plaintiffs Kashim Ali and his 1/4 interest over the land under CS Patta number 96, 97, 33, 124, and during his lifetime, he did not dispose of any of his property and died, leaving behind his two sons, namely Abdul Aziz and Abdul Hai, as legal heirs and successors to succeed his share and interest. On the death of Qasim Ali, Abdul Aziz, Abdul Hai succeeded his interest over CS Patta number 97 and 96 along with other pattas and possessing the same. In the meantime, Idris Mia died, leaving his two daughters, namely Asha Bibi, Laila Bibi. Idris Mia had one son perhaps, namely Talin Mia, who died prior to the death of Idris Mia, leaving his wife Hawaii Bibi. So, on the death of Talin Mia, his wife Hawaii Bibi somehow got her name recorded in CS Patta 97, although she never possessed any land in CS Patta 90 as submitted by its advocate for the plaintiff side. After the death of Idris Mia, his two daughters, Asha Bibi and Laila Bibi, succeeded the interest of Idris Mia. PW1 disclosed that Asha Bibi, daughter of Idris Mia, sold her share of interest inherited from her father to her sister Laila Bibi in the year 1941 by registered deed number T745 marked Exhibit 9, while the land under DAG number 687, 687, 687, 97 amalgamated and converted into single DAG and Patta bearing numbers so respectively. Exhibit 9 shows Asha Bibi sold 4 kata, 9 kata land from DAG number 527, CS Patta number 130 in favor of her sister Laila Bibi in the 1941. Laila Bibi bought her half interest over the property left by her father Idris Mia by right of inheritance and also got remaining half share of interest.
But Exhibit 8 was there.
There, my lord.
Madam, they have discharged their burden. Exhibit 8 has been is there, and the rest of the part have also been proved by PW1.
Exhibit, Lordship, Exhibit 397, I have seen that our names were mutated as per sale deed. Lordship.
Sale deed.
Yes, Lordship.
Which sale deed?
Exhibit 8 is a sale deed, Lordship.
In their favor, in the favor of their predecessor.
Lordship. Exhibit 8, that is after purchase from Idris Mia and Hauni Bibi, Idris Mia's daughters sold out the land.
No,
to them.
Exhibit 8 is a purchase from Badaruddin Chaudhary by Qasim, Idris, Abdul Rahim and Abdul Rahman.
Exhibit 8 is
Eight,
Sri Idris Mia Chaudhary or C. Rahim,
Abdul Rahim and Abdul Rahman.
Abdul Rahim and Abdul Rahman Chaudhary or Sri Qasim
Qasim Ali.
Ali.
They purchased from Badaruddin Chaudhary.
Whether it is a dated, Lordship. (1941), Lordship. Dated 1941. And our case is at 1912 and 13, Lordship. This sale deed is of 1941, Lordship. Subsequent sale. Lordship. Our case is that we purchased from Idris Mia and Hauni Bibi, Lordship. That Jamabandi also says by right of purchase. Lordship. our names were recorded: Sikandar Ali, Bakhtet Zaman, Kamrud Zaman, Pita Gabru Mia, Farida Sutre, 688 Dagpura, 1-2 number Chakine, 3-4-5 number Namdari. So on the place of Patada number 1 and 2, our names were mutated, Lordship. 1807 number Intekali, 13 Ingraji, that is dated 27/8/13.
Which is your exhibit
Exhibit 3, Lordship,
by you?
by plaintiff. They have exhibited, and that is application exhibit 12. I have stated earlier, Lordship, that is our application. Exhibit 12 by Lordship, দরখাস্তের রেজিস্ট্রারি বহিতে এই বছরের জন্য ক্রমিক দরখাস্তকারীগণের নাম সিকান্দার আলী, বক্ত জামাল, কমরুদ জামান, পিতা মিত্র গাবরু মিয়া। They have mentioned that Lordship Farida Sutre, 688 দাগ মধ্যে 8 কাঠা 3 ছটাক 9.
Their field is 41.
Yes, Lordship. That is dated 41. That is subsequent.
So, right?
Lord.
Your source is 41.
Here it is written that in my application, Lordship, Ukto Jomi
If
Joma
you have
Amora
required the right taken
Bainaga.
interest only in 41, then in 12, 13, where is the question of somebody else's name being inserted in the Jawabandi by college?
My lord, they have not exhibited a sale deed. They must controvert that by, my lord, saying.
No, from your exhibit, this exhibit 8 is of 41, 1941.
Lordship, can you go through our application? It reflects everything.
My lord, I find in page 42, I don't know what is this. No, this is in support of the claim, plaintiff filed registered sale deed dated number 8709, sale deed number so 1941, sale deed number so.
No, madam, you are mistaken. I think it is 1909. 1909, not 41.
Sale deed, Lordship.
Yes. There is a recording finding by the court. Page 40, internet page 18, first line. It's all right, first line.
Lordship.
In the year 1909,
09.
his father, Qasim, and his three brothers had purchased from Badruddin.
Deed of reconveyance marked as Exhibit 8.
We were wondering how can this mistake be done by the trial? Cannot be. 1909.
Eight 709.
So they have purchased from Badaruddin Chaudhary, Lordship, and we have purchased from this Idris Mia, Lordship, from that purchaser, Lordship. That we are not denying, Lordship. That is 1909 Idris Mia purchase.
No, 1909, not Idris Mia.
His
Their father, Qasim, and his
three brothers, Idris Mia,
Abdul
Rahman and Abdul Rahman. So 4 persons jointly purchased.
Yes.
We have purchased in the Lordship. Our mutation was done on the basis of our purchase from this Idris Mia, Lordship.
But that was not exhibited.
Yes, Lordship. That was not exhibited, but Lordship, our cancellation was not exhibited. The 1909 Lordship, Idris Mia may have purchased, Lordship. It is my vendor's deed, Lordship.
But you have purchased from Idris, you have to prove it.
It is not
Or
required
not you or your
if I am
predecessor?
able to disprove the case of the plaintiff lordship, it is
No,
not.
they have,
required.
it has the initial burden.
No, lordship,
1909 exhibit 8 has been proved.
yes, lordship, that I am agreeing, lordship, that exhibit
Now, if
8,
you say that you want to build up your own case, that from one of the vendors, namely
Lordship.
Idris, you have purchased, then at least you have to prove it.
lordship, on the basis of that purchase, our names were already recorded in the year 1913, lordship. And that it reflects from the Jamabandi and also, lordship,
That is precisely
their
the case of the
cases-
plaintiff. The
Lordship.
13 recording was by police or whatever, it was cancelled.
lordship, that cancellation order was not there, lordship. We denied that cancellation, lordship. For that, lordship, for overcome the point of question number 1, lordship, they have to prove that it was cancelled, and then again in the year, lordship, within the period of 3 years, means, lordship, 1996 and 1997, near to 1996 or 97, we again, lordship, re-entered our name. But that was not done, lordship. The point of limitation we raised, lordship, precisely in our written statement, lordship.
No, we don't have the sequence of events so far as the documents are concerned. Once we have the documents, what about the explanation that RS 132 did not have your name except 1 Sikandar?
Lordship. May I read the real facts for one, lordship? That is page 98, para A says suit
No,
second.
see, there exhibit 8, after exhibit proving exhibit 8, there is a further statement that after cancellation of the 1230 mutation in the subsequent RS Patta, except the name of Sikandar, the other names are not reflected.
Lordship.
That they're trying to build up a case.
Lord.
What is your reaction? There? RS Patta 137.
Lordship, that 97, we have stated in para B that Idris Ali, son of Sabu Mia, and Hauni Bibi, wife of Tolen Mia, were owners of entire land of CS Patta number 97 in equal shares. They sold away the entire land measuring 5 kathas, 7 chataks of land of Dag number 688 in CS Patta number 97 to Sikandar Ali, Waqt Jaman, and Kamrud Jaman, son of Gabru Mia, and their names are mutated in the Jamabandi of suit CS Patta number 97, and they became co-sharers of said Patta. They said Hauni Bibi, although was a recorded Pattadar of CS Patta number 97, had no possession over any land of CS Patta, and her entire land had been in possession of said Sikandar Ali, Waqt Jaman, and Kamrud Jaman, sons of late Gabru Mia, since the period of CS Patta, that is 1912 and 13 AD. Such possession of said Sikandar Ali, Waqt Jaman, and Kamrud Jaman was peaceful, exclusive as their own right, continues uninterrupted, open, and hostile to all, including said Hauni Bibi, since more than the prescribed period of 12 years. So as per share of Hauni Bibi, we are claiming adverse possession, lordship. Acquired valid right, title, interest over said land of Hauni Bibi by right of adverse possession long back about 65-70 years ago. That thus the above named Sikandar Ali, Waqt Jaman, Kamrud Jaman became absolute owners of entire land of Dag number 688 and half of the entire land of all other Dags, including Dag number 687 and 689 of said CS Patta number 97, and they have been in exclusive possession of the same since 1912 and 13.
Madam, this suit is not for recovery of position. It is for confirmation of position.
Lordship.
Where is the question of adverse position?
And we are saying, lordship, we are in possession. They are saying they are in possession, lordship.
They are only seeking confirmation of position.
Lordship.
They are taking the risk. They are not seeking recovery of position.
Lordship.
Only when there is a prayer for recovery, then you can claim adverse position as a matter of defense.
Lordship.
Now they are only seeking confirmation.
They are also claiming right, my lord. Both cannot go together.
Had it been a suit for recovery, yes, your defense, you are entitled to be adverse position.
Lordship.
And a degree of confirmation of position is not going to help them if they are not in position. While they pray for confirmation of position.
They are praying for confirmation of
If,
position and we are
if you are
saying
in
we are.
position, how are you aggrieved?
Lordship. Lordship,
Unless there is a
after-
degree of recovery that he is entitled to get back the position, it should not be aggrieved.
Lordship, after any decision by this High Court, Lordship, they are
We
they
are
may
only
create
acting as
problem,
a
Lordship.
second appellate.
Lordship.
Now, this is a primary prayer that there is a prayer for a decree for confirmation of position.
Lord.
Unless he is in position, such decree is not going to affect your right.
My substantial questions, Lordship, that suit is barred by law of limitation, Lordship. For that, Lordship, they have to overcome to show that the suit was within the parameters of law of limitation, Lordship. I have, Lordship.
What is the
stated-
finding of the appellate court regarding limitation point? Suit, issue number 2,
Upon the,
what is the discussion?
Issue number 2, Lordship, page 14,
Page 14.
1/4, Lord.
Appellate court is
Yes, Lordship. It is not correct that always concurrent findings will be right, Lordship. So many concurrent findings were
No, it's
reversed
not
by the,
necessary.
yes,
There is
Lordship.
a presumption that
If there is a pure question of law, your Lordship,
no,
there is
madam,
purpose.
even two people may make the same wrong, but normally presumption is
Lordship.
that wrong may not be committed.
Lordship.
And
Issue-
our jurisdiction is very limited to the second appellate court.
Page
Yes,
14,
yes,
Lordship, issue
yes.
number 2. This issue is decided by the learned lower court in negative against the defendants. I have gone through the discussion of the learned lower court of this issue, wherein it was discussed that the mutation of the predecessor in interest of the defendants, Sikandar Ali, Bakatur and Kamruzzaman was recorded in the year 1930, that is more than 80 years. It should be 1913, Lordship. And that the plaintiffs pray for cancellation of such mutation and also observe that defendant Abdul Mannan and Abdul Hannan and Ibatun Bibi also got their names mutated in the suit patta about 17 years back, and the plaintiffs did not raise any objection. The learned court below observed that the plaintiffs remain all along in continuous possession of the suit land and not aware of the fact that the defendants and their predecessor in interest illegally and collusively got names recorded in the suit patta till in the year 1994, while the principal defendants stuck their claim over the Schedule B land in the guise of false collusive mutation and threatened to dispose from the same. This collusive mutation came to the knowledge of the plaintiffs while they made inquiry on 17/12/94, 11/8/94, 3/12, these are the dates, Lordship, by obtaining certified copy of the relevant documents, and Exhibit 1 to 4 are the certified copies of the same. As such, the learned court below, while discussing this issue, observed that as per Article 59 of the Limitation Act, the period for 3 years to cancel and set aside the instrument or decree started from the date of knowledge about the fact of instrument or decree sought to be cancelled. I have gone through the Article 59 of the Limitation Act and also Article 110 of the same Act. The Article 110 provides a limitation of 12 years from the date of knowledge of exclusion when a person is excluded from a joint property to enforce a right to share therein. From the pleading of the plaintiffs, the admitted position is it was a joint family property and they claim the right, title, and possession over the same. Considering the above facts and circumstances, I find that the issue decided by the learned lower court is rightly and properly, and it is nothing to interfere with the decision in this issue. So there was no such discussion in regard to the point of limitation, Lordship. It was only discussed that it was a joint property. The plaintiff is claiming
There is one significant line. The learned court first line itself at page 15. The learned court below observed that the plaintiffs remain all along in continuous position of the suit land and not aware of the fact that defendants and the pressure in interest illegal and collusively got named recorded in the suit land.
It was, they were all along in possession and they could not learn about the wrong mention entry of the defendant.
Is 1994 from what happened in 94?
94, they threatened to dispossess, that's why they made it inquiry. That is the finding here.
Let us see your claim. What happened in 94?
It was just to
Page
show the
77.
continuity, Lordship. Just to show the continuity of the cause of action, Lordship, the 1994 was mentioned. And had it been a case that, Lordship, in fact, they came to know in the year 1994, Lordship, why they applied for the certified copy on 12/3/96, Lordship. They waited for 2 years then.
Where is the statement? 94?
Eligible my lord to copy. Really.
There was no such mention in Lordship within the statements made in paragraph.
When did Kasim die? Mr. Roy?
My lord,
When did Kasim Ali die?
Taslim Ali.
Because in paragraph 8A at page 6, internal page 6, running page 62.
After the death of Qasim Ali.
After that, then you had gone for mutating
No,
your name.
originally-
Can you say that you came to know about
Understood,
the
Lord.
inclusion of names of the defendant?
Yes, yes.
When did he die? This date may be relevant. Then we can at least assume that you have a genuine cause of action.
PW evidence करो, PW evidence evidence Just,
PW1 also stated that Kasem Ali died leaving behind, but the date was not mentioned.
What is the evidence? When did he die?
PW1 to huh? Oh,
In page 85, last paragraph, the principal defendant threatened to dispossess the plaintiff from a portion of their homestead land measuring about 3 katha 7 chatar. Only that much, Lordship.
but they have not also said that in reply, my lord, that Kasim Ali died much before. They have not said of Kasim Ali, the evidence.
The last cause of action paragraph only mentioned that the cause of action arose on and from different dates of obtaining the certified copies, that is 3/12/1994, 27/12/1994, and on and from different dates, and threatened to dispossession, that is
95.
3/6/95. So we created threatening in the year 95, and before that they'd taken the certified copies. Lordship. The pleadings are also contradictory. Lordship. There they mentioned that then and then they objected to the wrongful mutation recording of their names, Lordship, in the year 2019, 12 and 13. And then again they are saying from date of knowledge, Lordship. So there are contradictory statements by the plaintiffs
No,
themselves.
that part has been explained.
Lordship.
That prompt action has culminated in a cancellation, which
Lordship.
of course you are disputing.
Lordship.
But that
Only explained, but Lordship, there was no evidence in that regard. Lordship.
But Mr. Roy, just in a hypothetical case, you have paid for confirmation of position, isn't it? Right at an interest, decrease in granted. Just assuming that you could not prove your case. That by itself, they'll not get a right to encroach upon your land.
Yes, yes.
They'll have to file a suit to evict you.
That's fine, my lord. That's fine. And they did not, if they would have come with any evidence
And
that.
as you know, this is a settled position of law that records of right will not give them any title. That by itself, they cannot come and say that this is our land. This has to be adjudicated by a court of law.
As against that, we
So,
proved our title.
what is the substantial prejudice to either of the parties at this stage? I'm just wondering.
I'm in possession.
Madam,
Lordship.
even if you suppose we hold
Right.
that they could not prove their case, that by itself will not give you any
At least,
right to,
Lordship, my possession will be protected. Otherwise, after
your
getting it,
position is not been defected. Their contention is that the principal defendants have homestead land over dock number 650, which is contiguous to the suit land, and on the basis you are trying to dispossess them. And second is that you have a false and collusive mutation on the basis of which you are trying to dispossess. This action has been interfered with. The decree has been passed confirming their position. Your position is not disturbed over 650.
They will have to file a
And
suit.
if you want possession of this plot of land, you have
Lordship,
to file a suit.
Lordship,
They could have filed a counterclaim also. They have not.
So don't you think that the entire discussion or
Yes.
the efforts we are giving would be meaningless? Either way. Suit we cannot say meaningless because threat of disposition was there and court has protected them.
Lordship, whether there is any perversity or not, that is the main question. Whether both the courts have caused
No,
any
my lord is
perversity. Lordship.
saying about consequence.
Yes, yes, no, just hypothetically.
Because that's right.
If we assume that they could not prove their case, you just cannot go and dispossess them. First, you have to establish your right.
Lordship, that I
The
agree, Lordship.
entire burden will come to you as a plaintiff or maybe a counterclaim, whatever.
No.
But you will be the first person to go to the court that this is my source of right. They have been illegally possessing. Pass the decree. Without the decree, you cannot just dispossess them.
In the meantime, Lordship, what happened in between them, we could not say, Lordship. We are not aware about what is happening in between both the parties. They are,
Because our
Lordship,
discussion is on a very fine point, on a point of limitation. Second collision part, we do not like to go in. Even may assume that it's done by inadvertence, that also they are entitled to check. Even if we leave aside the allegation of collusion, that there was no collusion by your part, assuming that it was done by inadvertence, that will not be a bar for coming to the court. But the first question which you are raising, the point of limitation, that will still be there.
No.
Whether 2012-13, 1912-13, there was a clear cancellation which you are disputing, and if it was not, there was no cancellation, then whether suddenly after around 90 years,
Lord.
they can come up with the application for that.
And then again, the question, what will happen then? Your lordship is rightly put.
Lordship, if Lordship the suit allows, we will not, Lordship, get any benefit and will not,
So even if the
Lordship,
suit is dismissed, you are not getting it benefit.
Lordship. Lordship,
It's not a decree for
but
you
Lordship,
to,
the mental satisfaction the clients will get, Lordship.
after 100 years, there is no message. I think I have not.
For that only, Lordship, they engage me, Lordship.
But if to continue this on Thursday, but you take instructions,
Lord.
both of you.
Lord.
Madam, more reported. Because while this suit was instituted, matter was different. The set of dispersion was there. Now that suit was decreed long time back, 2000. Now in 2023.
I cannot do it also.
In the meantime, Lordship, I have taken one information that in the meantime that the disputed portion was already constructed a park, Lordship, by the government, Lordship. So even if Lordship had, it was dismissed, Lordship, they will not enjoy. All the persons of the village are enjoying that portion, Lordship. It was already constructed like a park.
Withdraw the appeal then. Withdraw the appeal.
No,
Lordship.
If
No, for
come from both of you, then we can record something. But not only honor something.
Because
no, I have been engaged, Lordship, by some other person, so I have no connection with the clients directly.
well, it came to me after so many hands. I also do not have direct contact. I lost my learned friend too.
Now we noticed that the pending is 2000.
That's right.
Your Lordship in Partha.
We are here, this basis, we can have a day after tomorrow.
Lordship. Thursday.
So they will remain in the list.
Lordship.
Because they are the court of
Thursday at 2 p.m. Lordship.
it will be released. What to say? We'll discuss. We'll have it on Thursday.
Lordship,
Both of you,
Lordship.
you try to have the instructions and be present at your convenience. But we'll take it up. Thursday we are going to complete.
Lordship, can it be on Thursday at 2 p.m. Lordship?
As per your confidence,
Lordship,
it's part two method.
Right.
So normally it will come at 2 o'clock.
oblige.
May I please, my lord? My lord, I'm on behalf of Mr. S.P. Chaudhary. My lord, in this case, my lord, we were the earlier engaged counsel. Here the petitioner has withdrawn the brief from us and they said that they will be appointing the new counsel. But time and again, this matter has been listed, but my senior's name has been reflected, my lord. So, my lord, since we are not appearing,
None appears for the appellant or call. Your name?
K. Vishwakarma.
Three. Here for the
And for the respondent number 2, Lordship.
Agarwal, last occasion also none had appeared.
Yes, sir.
What is the
Before
matter
that-
about the testamentary appeal?
Yes, Lordship.
What is the appeal about?
In this case, Lordship, the appellant challenged the probate order passed by the additional learned district session judge. Father of that petitioner as well as the opposite party executed one bill. Thereafter, one probate suit was filed that was allowed
By you? By you?
Yes. Lordship.
Then?
And that was allowed. And that
After
challenge.
notice,
Yes, Lordship.
it was contested.
Yeah, contested, they file objection. Or thereafter that probate bill was allowed and passed. Probate certificate was
What is the status? Was there any stay order?
stay is there.
Stay order is there.
Stay, most probably on the
In the IA.
in the test appeal, we have got the order, the appeal is admitted. It never, no stay.
Interim order was there. There will be an IA.
Oh Lord, so that we have not received.
What was the subject matter involved? Property involved?
Property is at the Yarwadi Beltala, 2.5 kathas of land was there. Of the father of the appellate at the opposite party. That they are claiming on the
This land was is part of the will.
lordship.
You are the beneficiary.
Lordship. The father executed the registered will in favor of the petitioner.
None appears for the appellant on call. Whereas three. S.K. Agarwal.
Lordship.
Counsel for the respondent number 1 is present.
Respondent number 2, Lordship, I am afraid.
Respondent 2.
Lordship.
For 1.
For 1, Mr. J. Sharma is appearing.
No,
With this-
2 is present. There is continuous default on the part of appellant for the last 3 dates, namely 5/6/2018, 28/3/2020, 25/4/2020 and 16/5/2023. Full stop. In fact, on the last date, that is 16/5/2020, this court had made the following observation. Quote, Three, as Vishwakarma,
K.
K.
Vishwakarma.
Vishwakarma, Learned Counsel, however, submit that though he is senior, Sri Chaudhary,
SP Chaudhary, my lord.
Sri SP Chaudhary was earlier engaged on behalf of the appellant, the brief was taken back, taken back long time ago. And it appears that no counsel has been engaged. That be that as it may come, in view of the constitutional default on the part of the appellant, and also the caveat, and also the observation, and also taking into consideration the observation of this court of the last day from instead of it is dismissed for want of interim order passed 30th 10th second.
Obliged, my lord.
Deeply obliged.
My pleasure, Lordship. Lordship, I am on behalf of MU Mundal. Lordship, please kindly pass over the matter for the day.
And that case for
No, injury case, they have come for enhancement, Lord.
with their appeal,
Their appeal, Lord.
how much was the award?
1,30,000.
What was the-
1,30,000.
What is the nature of the injury?
Injury, Lordship, their enhancements, it won't stand, Lordship, in view of Rajkumar Ajay Kumar case, Lordship, because
What was the nature of the injury?
injury was a fracture of his leg.
Fracture.
Yes.
You are a government servant.
No. He has a business and he proved his trade license also. And trade license was effective during his accident as well as it was issued after the accident. So there cannot be any loss. So since they have come in the appeal for enhancement based on that disability, that court has not given them any disability amount. So that won't sustain the, but I think
Was there a board, medical board? No.
medical board, yes, doctor adduced evidence.
What was there was no certificate granted.
Certificate was granted. But Lordship, the settled proposition of law is that disability itself is not loss of earning.
No, cannot. Disability has to be connected with the earning.
Exactly. That's what will be our case, Lordship. So I think what they say,
We'll have it day after tomorrow.
yes, Lord.
Ask your senior to be here.
If I have a small something to make, if I was appearing for restaurant number 3, my
Who's free?
Reliance, doing the signature there. If what is the kindly see order date 29/22?
Yes.
That if I had withdrawn my wakalat initially, okay? But there is a letter from the interest company to appear again in this case, my friend.
You appear. What you talk? Your name to be recorded.
Yes, my name is there in the call.
Does not make any. A prayer for adjournment has been made on behalf of the appellant, who by means of this appeal has paid for announcement of the award passed in a motor accident case. Sarah? This office is directed to this case for hearing on Thursday or Friday. Friday, Thursday we have got Friday. We have
21/8/23.
got-
21. Friday,
Friday.
21. no? It
Your,
took
uh,
21.
24th, Friday.
Much obliged.
You have that, what is the citation, madam?
I have a copy of it for lordship.
There has been explained in a number of other cases also.
Yes, but most of them they follow this citation lordship and take Rajkumar Ajay Kumar. 2011 1 SCC 343.
Yes.
Highly obliged.
May I please, Lordship?
Better
Madam,
number,
in-
15, yes. MSC.
Yes, madam.
Pray
My
for
lord, in this
improvement.
case, my lord, I could not submit written evidence on affidavit. That is why this case was dismissed by the court below. My the impugned judgment is case 16 to 19.
Why didn't you give your evidence?
My lord, on that very day, my lord, the claimant could not appear before the court below due to his illness, my lord. In this regard, I have filed an application.
Your adjournment has been rejected.
Rejected and judgment was passed dismissing the application.
No, my lord, on 14 to 2020, they are absent without any steps, my lord. Then, and Learned Court will has given 11/3/2024 CWS last term. On that day, they filed application, my lord. And the findings of the
Application for adjournment.
application for adjournment. And the findings of the court is
Did you
that
present your evidence?
My lord, I could not submit due to the illness of the
Oh,
claimant,
you are not
my
too
lord.
well.
Yes, my lord. In this regard, my lord, I want to submit
That case,
death case, my lord.
who passed away?
My
husband has filed
my
the
wife-
case.
My wife died, my lord. My lord, as per judgment of
When did the accident happen?
my lord, this accident occurred, my lord,
2017.
in the year of 2017, my lord.
What do you do?
My lord, I am private job. I'm doing as a private.
What kind of private job?
My lord,
Taylor. As per
Okay,
claim
Taylor.
petition, Taylor.
And what did your wife, this is wife, she
This
was she was doing something.
deceased
my lord,
wife was a
this
Taylor.
was a private employee, my lord, which is stated in my.
What kind of
Okay.
employment?
My lord, he was a private employee some company, my lord.
What job?
Now, as per claim petition in paragraph number 5, it was stated deceased was doing working as
Number
Taylor.
8, my lord.
Taylor.
And then he and the claimant,
Claimant he has not stated.
Not
your wife was a tailor.
in a private job, my lord. Page number 8, my lord. I have stated in column number 4.
You do not know what was your wife was doing.
My lord, I have not submitted the evidence,
In-
my lord.
You do not know. Do
Annexing
you
the-
know or not? What job your wife was doing? You do not even know.
My lord, he was an employee of a private company, my lord. I would submit the written evidence on affidavit.
Your
Exhibiting,
wife passed away. You don't even know what kind of job she was doing.
my lord, he
This is
was
the
a-
husband. Where have you stated?
my lord, as a private employee.
That is a very gentle statement, counsel.
That is
What
why,
private employee?
that is why I could not, I have not, as per instruction received from my client, my lord, I could not receive
We
the,
don't see the counsel, we see the person who is behind you. You have not taken the instructions what the wife of your client was doing. Is there any statement?
yes, my lord, page number 8, my lord.
Page 8.
Yes. Column number 4, occupation of the deceased.
That we have seen, but we are asking you, what kind of private job?
As per instruction received from my client, madam. He was an employee of a private company.
Name and address of the employer, Taylor. Mean, but where is any other information? Let us at least 10. And what do you do?
But my submission is that, madam, this case may be
What do you
remanded
do? What is your job? Hassan Ali, you're 52 years, able-bodied.
as per the occupation of the deceased, my lord, the amount.
What do you do? Where you are dependent on the wife?
But he is a laborer, madam.
Were you dependent on your wife?
Yes, madam.
You're
As
dependent.
per MVF, my lord, he is a dependent. Motor Vehicle Act, 1988, my lord, as amended.
What is the meaning of a dependent?
My lord, he was dependent.
What is the meaning of a dependent?
But as per when he earned some money from any private company or any other.
The wife was the sole breadwinner of the family or what? Or did you earn anything? Yes, madam, what do you say?
Nothing was written whether he was dependent or not.
No, that is, we are discussing at the very case is not that, it's not even been adjudicated. It's been dismissed.
Claimant failed to,
Let us see the impugned order,
in order is the case 15 million,
50.
15, annexure 4.
My lord, the relevant portion is case 18, my lord, para 10. May I read, my lord?
Yes, please.
The record reveals that after facing the issue, the case was posted on 14 February 2020 for claimant's evidence. But since then, till that, the claimant has failed to adduce any evidence. Last chance was given today for CW, but the claimant has failed to comply with the order and file a petition praying for another date for evidence. However, the said prayer is rejected as such. Hearing argument for OP, the case is fixed for judgment today. As the instant case is a very old pending one since last.
MSC case can be dismissed for default.
Here judgment was given, my lord.
That is it. He is not been able to prove his case.
The claimant failed to prove the case by adducing evidence. Discussion was made.
My lord, I want to submit on judgment of apex court matter. That is reported in 2010, my lord.
Yes.
Joy Prakash versus National Insurance Company Limited and others. My lord, page number, my lord, 611, my lord. Para number 9, my lord. Page number 611.
Para 9.
9, my lord.
Yes.
In this judgment, my lord, Supreme Court clearly stated that as per section 158 subsection 6 of the MVR, when the accident occurred, the police has to send the accident information report, that is form number 54, to the concerned tribunal.
Correct.
And thereafter, my lord, as per section 166 subsection 4 of the MVR, the claims tribunal shall treat the
said accident information report as application for compensation. My lord.
Hmm.
This is the beneficial legislation, my lord. But the tribunal arbitrarily, my lord, dismissed this case.
How has got this,
Only- Only
how has got this case any relevance in your matter? This is only registration of an application. It is a case, is it your case that the case your claim was not even registered? It was registered.
my lord, my submission is that as per this judgment, my lord, the claims tribunal should inquire whether accident was occurred or not, whether he is entitled to
That means there is no requirement of any adducing evidence.
as per this judgment, my lord,
No evidence is required.
evidence is required. my
Then
lord.
there are, this is not a judgment.
I was not.
Your lordship may kindly.
There will be other judgments that MSC case with the lenient approach is required. This is not something we are looking for.
I may be allowed to
We'll have it day after
given an
tomorrow.
opportunity to adduce evidence.
No, you, day after tomorrow, you come up with judgment. We'll have day after tomorrow. There are judgments. Your name
Yes, Islam, my lord.
on the prayer of PS counsel for the no, God PS counsel for the appellate, whereas MS Troy.
Aspect number 1.
Appear for the aspect number 1. Right. What is your name? A Das. Semicolon. A Das. Counsel for the aspect number 1. On the prayer of the correct of the petition appellant. Raise this matter again. On again for hearing on therefore. Okay, rest.
Hello.
Mr. Dekka, you are sitting for long, which matter?
3 million.
Item number, we have it later. We'll try it later, tomorrow or day after. Item number 3,
3 million.
what is the matter?
My lord, against reverses findings, my lord.
Other side,
I inform my lord, in the part, not getting any response from them today. The may pray, my lord, can it be taken out Thursday, my lord?
so we'll see tomorrow or day after, we'll have it. This, for, this matter is till 2010 will complete.
Then, my lord, if address is not available tomorrow, then I can proceed, ma'am.
Tomorrow we do not know what is the list, we'll see the position. Try to inform them.
Yes, ma'am.
You're the plaintiff,
Yes, my lord.
to dismiss.
Trial
Concurrent.
court, my lord, is declared
Affirm.
in my favor, my lord, against the appellate court order you are here,
Reversal.
reversal.
Anybody for 17?
Yes, ma'am.
Yes, for the petitioner.
My lords, I'm for the respondent.
And for the petitioner, your lordship, Mr. Senior Advocate, Mr. P.J. Saike is appearing as
What is
petitioner.
this matter?
My lords, this issue has already been settled in Nepal Das by this very honorable court, Your Honor. Now, the issue is this, that the petitioner is praying that 4 documents should be allowed to be produced after the plaintiff evidence is already closed, my lords.
Documents of whom?
Documents of,
Plaintiff.
The petition.
yes.
Petitioner
So
presented.
there is not a whisper of the reason why they were sitting on the same doc.
We'll have
They're
it,
saying
we'll have this day after tomorrow if there's a.
Lordship can.
my lords, there's
explain-
only one request, and it's a little bit of a pragmatic request, if you may
Yes,
bear with me for 2 seconds. There is an interim order passed where a stay has been granted in their favor, saying that the evidence should not be led in the courts below. I'm saying, my lords may consider vacating that stay on the condition
No,
that
today
if
we
they
do not have the time to consider. We'll have it day after tomorrow.
day
if
after
you-
tomorrow. Yeah.
Come prepared day after
Oh,
tomorrow.
my lords, I'm so sorry. On the 20th, I'm engaged in a different matter.
Lordship,
Tell
if
us a date of
possible,
your
let us have
convenience.
it on in the month of August, your lordship, if possible.
There's
First
an
week of
interim order. It's affecting him.
Any day after the 20th.
Tell us a date of your convenience.
25th, we also did it.
25th.
25th Tuesday, very good. Yes,
Lordship, senior counsel would be out of station. on that
27th.
particular- For those particular
27th.
days. Lordship, if possible.
My lords, they've been asking
First-
for dates after dates.
Lordship,
They're sitting on a stay.
On the last occasion, it was the respondent. who
Now it's
sought-
becoming
sought that.
intentional, my lords. I mean,
Lordship,
don't make that kind of statement.
I apologize.
We are there to see.
I
whether
apologize.
it's
I
intentional or
apologize. I
not.
reject.
on the last
Making a
occasion, it was
statement
the
against
respondent. who
council, we
sought
don't
that.
like.
I apologize.
On first
1st of August,
of August,
First of all,
first Tuesday,
deeply obliged. Interim order, something.
a prayer for adjournment has been made on behalf of the petition, which however has been opposed by the learned counsel for the respondent. As there is an interim order pen, interim order operating for para, keeping the same into consideration, that this matter be listed on 1st of August 2023. This will come for hearing over,
yes, Your Honor.
for hearing. Put up interim order passed to continue to the next.
Obliged.